Item number 19, 14. Item number 15, 21.
Item number 19. Item number 19, my lord, we were required to file an additional affidavit for the state, my lord, the matter of continuation of delay. I seek a week's time, my lord.
And concept of the state place for granted 1 week's more time to file an additional affidavit.
I appear for the respondents in the matter, my lord. We filed our wakalatnama today, my lord.
Notice was not required.
Presence for
Lordship, I'd like to mention item number 17, Lordship. Lordship, I could not take steps, your Lordship. I've taken just now, your Lordship. It may come up after 3 weeks, Lordship.
the concept of the, you are for the petition,
Appellant, Lordship.
applicant. Then concept of the applicant has submitted the steps. Required steps have already been taken. Full stop, office to check and if the steps are taken. Let notices be issued to the respondent of the IA returnable on so and so. 3 weeks.
Item number 22, 21.
May please, the Lordship. I beg to mention item number 23, 24, and 25. Lordship,
23, 24 and 25. Yeah.
Lordship, this is a common, the writ appeal has been filed against the common judgment and order. Another writ appeal is pending before this honorable court and fixed 3rd June, Lordship.
3rd June.
Yes, Lordship.
But in that appeal, I think the notices have been issued and stay has also been granted.
Yes, Lordship.
Where is that order? Where is that order? Passed in similar appeal. Let the matter, bring that order. When your turn comes, appear.
Sorry, Lordship, I have not bring my file, Lordship.
Okay, now obtain it. It will take some time in coming of a matter.
After some time, Lordship.
By the time you bring that order.
Okay.
Maybe the Lordship, with the consent of the other side, Lordship, I beg to mention item number 31 to 33. Kindly as well, matter for the
31 to 33.
Highly obliged.
Arjun. Yes.
May I please, the Lordship? Lordship, I beg to mention item 41 of today's list, my lords.
41.
Lordship, with the consent of the other side, Lordship, here our report is still awaited from certain districts, my lords. So, Lordship, we seek 2 weeks accommodation. I'm appearing for the health department, Lordship.
You are appearing for the health department.
Lordship.
On 3/5/2024, you are directed to file an additional affidavit.
Yes, Lordship, here the issue is that since the district, all the report is not present, my lords, because of which we are unable to file the affidavit because it will be
Kill and concept of the appearing for the state. Place for and granted
2 weeks.
2 weeks more time to file required additional affidavit. Yes,
My lords, I appear for the petitioner in this matter, my lords. May I pray for a fixed date, my lords?
ask the court master. Will give the-
Lords.
May I please your lordship? Lordship, I beg to mention item number 36. With the consent of the other side, can the matter be adjourned for today, lordship?
Arjun, 6 weeks.
Obliged, your lordship.
Lordship, with regard to item number 43, I have obtained the consent from the other side, Lordship. Let this matter come up next Friday, Lordship. Here we have to file an IA, Lordship.
43.
On Friday, Lordship. .
Arjun,
Obliged to your lordship.
May I pray, Lordship? Lordship, with the consent of the petitioner side, Lordship, I beg to mention item number 50, Lordship. Also, kindly this matter may be adjourned for the day, Lordship. And Lordship,
50,
50, Lordship.
50.
Can it be
Mr.
taken on Thursday, Lordship? Can be taken on Thursday.
Arjun. Yes,
I prefer dating. I'll take.
Please, your lordship. Lordship, I recommend item number 19, your lordship.
19, yes,
19, your lordship.
yeah,
We need 2 weeks time to file an additional affidavit, your lordship.
19 has already adjourned. Already in.
Daily list for orders item 1.
But in this matter, state is required to
Yes,
update it further.
that alternate road.
I have received the status report, Malak.
Earlier you-
But they have said that
Earlier you gave undertaking that would be
We didn't-
completed by
within
30th of May.
within May, they said, Malak. But now the progress is 65%, they said, Malak. And the progress is 65%, Malak. Within
Last occasion, you made a statement that the construction would be over by 30th of May.
correct, Malak.
May, end of the May.
Yes, Malak. They said, but now they said that by mid-June, they will finish it, Malak. But there was some disturbance from the local public, Malak, at the portion where, at some portion, Malak. That is why there was some stoppage and all these things, Malak.
What was the disturbance?
But some people, Malak, while constructing the road, the upper portion has been already done. In the lower portion, Malak, some disturbance was there. The contractor, the laborers were stopped by them, Malak. And then that is why, Malak, I have also informed my learned friend, Malak, that some disturbance was there.
My friend has informed me, Lord, 2 days back, there is only one incident.
No,
Whether-
before also some there on day before yesterday also I informed him.
Fine, my lord, we are concerned with, my lord, early construction and completion of the work, my lord.
Lordship may grant them 3 weeks time, Malak. Kalau mana nilainya, kalau kita jadi
देखिए, on 2/4/2024, Mr. D. Nath, senior advocate, Assam, has made a statement before this court that the construction of the alternative road would be completed by the end of May 2024. Would stop. Today, Mr. Nath has informed this court that on account of some trouble created by local residents, the road, the work of the construction of the alternative road was halted for over a month. And therefore, the road could not be completed. He submits that now the road would be, the construction of the alternative road would be completed by mid-June, full stop. Taking into consideration the above facts and circumstances of the case, we deem it appropriate to direct Mr. Nath to file an affidavit of the concerned official detailing with the detail that who has created trouble in construction of the alternative road and whether the dispute regarding the whether the land related conflict at a lower Mali Bagan point has now been resolved or not. This matter on 18th of June.
Deeply. Okay.
Item two,
But the instructions which I have received, that may be kept on record. The instructions I have put.
You file the,
Lodge.
along with the additional.
Lodge.
My lord, today I am filing my affidavit, my lord. Let this matter may place for hearing, lord.
It
is already admitted, my lord.
already admitted. And council has submitted that.
Rule was issued, my lord.
Then council for the petitioner has submitted that the rejoinder to the reply filed on behalf of the respondent will be filed during the course of the day. Full stop. It is noticed that matter has already been admitted. Lest this matter, hence, lest this writ petition for the hearing
My lord.
in due course.
item number three,
May it please your lordship. Well, in this matters, the service upon the private respondents is still awaited. Since this matter is pending since 2021, may I pray that I may be allowed to take substituted service by way of paper obligation, my lords, in a local daily in Arunachal Pradesh, my lords.
Send it by registered AD.
We can send it.
Earlier, there is no order of sending it by registered AD.
So we had sent it, my lords.
No.
The order was of 18/4/2022 when notice was issued. We had sent it.
There is no order of registered AD. Notice issued to the respondents on 18/4/2022 has not been received. The notice issued to the respondent has not been served since long. Full stop. Taking into consideration the above fact, we deem it appropriate to direct the appellants to get the notices served upon the respondents through publication in daily newspaper of Arunachal Pradesh,
Arunachal Pradesh, my lords.
of state of Arunachal Pradesh in vernacular language within a period of 1 month. Full stop. The copy of the publication of notice be placed on record before this court on the next date of hearing.
I'm deeply obliged, my lords.
1 minute. Vernacular newspaper. Is there a vernacular newspaper in Arunachal?
No vernacular, lordship. It's English daily.
Daily newspaper that.
Obliged, my lords.
Obliged, lordship.
item number four,
My lord, as per the last order, the district commissioner was
Supposed to file a response,
and that response has not been filed,
not filed.
not filed.
Yes,
My lord, in the meantime, I'd like to bring to the notice of this honorable court, my lord. There has been art filling going on the Deeporville area, my lord, on the Deeporville actually.
but now there is a affidavit already, the Supreme Court has also passed some order in relation to Deeporville area.
Yes, my lord. Well, regarding the perimeter of the Deeporville, that has not been ascertained. That is why its protection has become redundant, my lord. Because there is a change in the land use, because of which the area will shrink now.
Who
This
is from
is-
the government, Mr. D. Sekia was appearing, Advocate General earlier appeared in the matter.
Well, the garbage dump is continuously burning now and creating a lot of pollution in the city, my lord.
That garbage is something that's not in this matter.
My lord, in the petition, there is regarding the garbage dump. There is shifting of the garbage dump. Now they want to build a solid waste management
Well,
plan.
AG,
Yes, Lord. On last date, AG appeared in the
this, District Commissioner Kamrup was supposed to file an affidavit.
Yes, Lord.
So yes, what do you mean by yes?
No, Lord, I am appearing for the GMC authority, Lord. On last date, AG was appearing, I was assisting because Lord, Learned Counsel for the Forest Department was not there. And the direction was issued to the Deputy Commissioner, Lordship, as regard the demarcation of the Deepor Bill area.
So what happened? Why you have not filed any affidavit? Then we'll call the commissioner.
Lord, whether it was communicated to the Deputy Commissioner.
But that is not our headache, that is your headache. What is this happening?
Lordship, that instruction I can take, Lord. But in my last affidavit, Lordship, filed in the IA, Lordship, there was specific mention was there, Lordship. So far as the forest area is concerned, Lordship, no art filling work is going on. That was the categorical statement in my IA, Lordship.
Sir, last occasion on
Yes.
8/2/2024, there was a statement on behalf of Learned Advocate General that draft notification declaring Deepor Bill Wildlife Sanctuary as eco-sensitive zone has already been prepared and same will be placed before the state cabinet for approval within a period of 2 weeks. After approval from the cabinet, the same shall be forwarded to the state government for final approval. The process may take around 6 weeks time and therefore we have listed it after 6 weeks. Now, in the meantime, if the landfilling is going on, how?
And there was a IA, my lord, they wanted to denotify the wildlife sanctuary part.
That we have already
Yes,
stated.
lord.
That we have already
Is already taken
So
care of.
since
Lord.
the perimeter is not fixed, my lord, there cannot be any solution, my lord.
Lordship, only the demarcation part, Lordship, if allows me, Lordship, I will take care of that instruction, Lordship, and I'll
When?
place it
When?
immediately, Lordship. I'm praying for 3 days time, Lord.
Till the demarcation
And
is made, my lord, no art filling may
Come
go
at
on.
2.
Today, Lordship.
Yes, today itself, come at 2. And give the answer of that. Whether land filling is going on or not.
Lordship, for land filling, Lordship will have to allow me some time, Lordship, so that some
Yes.
inspection can take
You
place.
just take the instructions by 2.
Item number 5.
As per office note dated 25/2024, service upon respondent number 6 is still awaited.
Await service of notice upon the respondent number 6 for 3 more weeks.
Obliged.
Item 6.
My lord, upon respondent number 4, 6, and 7, service was to be not completed, my lord. My lord, today my colleague is appearing for respondent number
4 and 7, Lord.
4 and 7.
What about 6?
6, my lord, I may be permitted to take fresh steps in alternative address, my lord. He has now presently posted in Sipsagar, my lord.
Okay, Mr. So and so put in appearance on behalf of the respondent number 4 and 7, learning counsel for the appellant. Praised for and granted a week's time to take fresh steps for service of notice upon the respondent number 6.
In alternative address, my lord. In a correct appropriate address, my lord. Present.
Appropriate, yes, certainly you are supposed to file correct notices on so. Take steps on on taking such steps, let notice be issued to the respondent number 6, returnable 3 weeks thereafter.
Obliged.
Obliged. Show their name.
Item number 7.
Eight previous year also. I'm appearing for the respondent, my lord. We have preferred an SLP, my lord, being SLP number 24370 of 2024, my lord.
So
Is likely to be listed after ongoing summer vacation, my lord. Sometimes maybe given, otherwise we will take no time in making
review
payment.
petition has already been dismissed.
That has been dismissed, my lord.
Yes,
So otherwise, my lord, we will take no time in making payment once this SLP is disposed of.
make the payment, subject to this, we'll ask him to give an undertaking that in case the SLP is allowed, then he'll pay the,
That may observation maybe then we will take care of. If that can be taken care of, my lord.
certain. This contempt petition is filed on behalf of the petitioner, alleging that the direction given by this court on 13/9/2022 in DB civil writ, in writ petition number 214/2019, as well as in writ appeal number 26/2023 has not been complied with. Full stop. The single bench of this court, as well as the division bench of this court in the aforesaid orders, has issued a direction to the respondents respondent number 123 of the writ appeal of the writ petition as well as the writ appeal. They have, to the respondents to release the balance payment of the petitioner in respect of additional 52.5 kilometer at the rate of rupees 10.98 per MT per kilometer within a period of 60 days. Within a stipulated time. Full stop. It is informed that a review petition against the order dated 9/8/2023 passed in the writ appeal 26/2023 has already been dismissed by this court. Full stop. Where learned counsel for the respondent has submitted that against the order of the division bench dated 9/8/2023, the respondents have already preferred an SLP, which is likely to be taken up for the hearing before the Honorable Supreme Court after the ongoing summer vacations. Stop. It is, we are of the view that since no stay order is passed in the, no stay order is operating in favor of the contemners, they are required to comply with the order passed by this court. Full stop. Learned counsel for the contemner has submitted that the respondents are ready to make payment to the petitioner as per the direction given by this court. However, he prays that some protection be, however, he prayed that the petitioner will directly file an undertaking that in case the Supreme Court, Honorable Supreme Court interfere in the matter, then the contemner would repay the amount so received. Yes, full stop. Learned counsel for the petitioner has no objection and is ready to give an undertaking of counsel for the petitioner has submitted that the petitioner is ready to give such undertaking. Stop. In such circumstances, we deem it appropriate to grant the respondents 2 weeks time to make the payment to the contempt as directed by this court. Directed this court subject to the condition that the petitioner shall file an undertaking of this effect that in case the Supreme Court interferes in the matter and pass an adverse order against him, he will repay the amount so paid to him within a period of 4 weeks thereafter. Would stop. This matter, when
After vacation, my lord, our vacation.
why vacation? You make sure that payment within.
That
2
will
weeks,
be-
make the
that will
payment,
be-
and then we'll dispose it off. This matter on
Last week of June, my.
19th of June.
Oblige.
Item 8.
My lord, in this appeal, my pleadings are complete, my lord. They have filed affidavit. We have also filed reply, my lord. Let it come after 1 week, my lord, on a,
Why this IA is there?
for vacation of interim order, my lord.
So argue it on IA or either withdraw it, then we'll hear it finally.
Then after some, then MK Sudhiri sir will appear, my lord, in this.
Yeah.
case. Senior counsel, my lord, MK Sudhiri will appear, my lord.
You withdraw this IA and argue the appeal finally.
And after some time, my lord.
Then why to press this IA? Argue the matter finally.
Yes, then after some time, or tomorrow, my lord.
Okay. The matter comes upon for consideration of the IA number
Tomorrow, let it be day after tomorrow.
3581/2023, seeking vacation of the interim, vacation oblique modification of the interim order passed by this court on 17/10/2023. Would stop. We are of the view that the writ appeal itself can be decided at admission stage, and therefore we deem it appropriate to list the connected writ appeal number so and so for final hearing on 10th of June.
Yes,
On 10th of June.
my lord, interim order passed earlier itself.
In the same order, it's already there. Yes. That can't be vacated automatically. It's a appeal.
Item 9.
So you have not taken steps.
I have taken steps, Lordship, last week.
Yeah,
Last week I have taken steps.
when? As per the
On-
office report, you have not taken the steps.
On 24/5/2024.
No fresh steps. This one. As per the office report, you have not taken steps for service of notice upon the respondent number 12 and 13.
Fresh step.
No fresh steps.
Lordship, we have taken steps on
When?
24/5/2024.
24/5.
Yes, Lordship.
It's 24. Legal and answer to the petitioner that submitted that pursuant to the direction given by this court on 6/5/2024, he has taken steps for service of notice upon the respondent number 12 and 13 on 24th.
24/5.
24th of May 2024, office to check in the, and if the steps are already taken, taken. Let notices be issued to the answered respondents, returnable answer.
112 and 30.
112 and 13. Yes.
Item 10.
So in the I, we have taken steps with the the report has not come, and the lordship may allow us to take fresh steps.
When you have taken step?
Well, once we file the,
Written, I will click it.
once we
The
file the,
notices issued to the sole respondent has not been served. Till date. When consent for the appellant is directed to take fresh steps for service of notice upon the respondent. On taking such steps, let notices be issued to the sole respondent returnable on consent.
lordship may give it 3 days time. Lord.
Item 11 to 13.
Well, pursuant to the last order at 3-5, we have taken steps. 3 weeks further may be granted to complete the service.
When you have taken steps?
On 20th, 20,
20.
by Dusty as well as by registered post.
Then we'll await the notices. You are.
My lord, I am for item number 11. In fact, in item number 11, the delay has already been condoned, my lord.
That appeal has been numbered.
That appeal has been numbered. Though my name is shown in item number 12 and 13, it is wrongly shown, my lord. In that case, lordship may take up item number 12 for admission on some other day. Though it is connected, but
The common judgment, it's against the common judgment, there are 3 writ petitions.
Matter is to be heard. All these matters are to be heard together.
Yes, the writs were also heard together. There's a common judgment.
the thing is, my lord, for the other 2 writ petitioners, this item number 11 is getting delayed because as per the order, last order was passed on 3-5 and the steps was taken on 20th, my lord.
2 weeks, we granted 10 days time to them. Yes, learning council for the appellant. For the learning council for the applicant has submitted that steps for service of notice upon the respondents has already been taken. Are taken on 20th of May 2024. Full stop, office to check and the steps are taken. Let notices be issued to the respondents returnable 3 weeks thereafter.
I'm good.
Item 14.
May I please, Lord? My lord, there is an I, Lord, regarding condonation of delay of 19 days.
Who is appearing for the other side?
Other side, Lordship, on last occasion, Mr. D.K. Sharma was appearing, Lordship. He is for their Lordship.
You are appearing.
Yes, sir. I prefer education department.
Do you have any objection in condonation of delay? The matter comes upon for consideration of the IA number so and so with a prayer to condone the delay of 19 days in filing the connected rate appeal. Stop. Notices have already been served upon all the respondents, however, no response, no counter to the IA is filed till date. Having heard the learned concept of the petitioner for the applicant and after going through the contents of the application, we deem it appropriate to allow the IA number so and so. Hence, the IA is allowed delay of 19 days in filing the connected appeal is condoned. The registry is directed to register the connected appeal and list it before this court after 2 weeks for admission.
Highly obliged, Lordship.
Item 15.
Yes, in this case, my lord, notice was returnable in 6 weeks, my lord. That is expired along that, my lord. And it was stated, my lord, also that the interim will be considered after service of notice, my lord.
Notices have not been served till
My
date.
lord, most of the respondents received notice, my lord.
When?
My lord.
In view
card
of
has
the above, the
returned.
petitioners have obtained instructions regarding present address of respondent number 2, 4, 7, 8, 16, 18, 19, 20, 21 are there so many within 7 days from the date of this order.
The other respondents received notice. my lord. Also, my lord, they have come up with contempt proceedings, my lord. And they have been appearing, my lord, their counsels are appearing before the tribunal.
Sir, here who is appearing for these, all the respondents,
My lord, Mr. DP Bora.
all the respondents?
Yes, all the respondents.
Where is Mr. Vora?
I'll be calling him up, my lord,
Call him after some time.
deeply outlined.
Take up.
Item 16.
May I please your lordship? In this case, an IA has been filed, IA numbered as 1509/2024 for impleading District Elementary Education Officer Karimganj as respondent number 5 who was inadvertently left out while filing the appeal, your lordships.
Left out?
Actually, it was an inadvertent mistake on my part, your lordship.
On your part.
Yes, your lordship.
Now, what do you want?
Implead, to implead.
But the notices to the other respondents have not been served till date.
Others are served and appeared on the last date, your lordship. WPT and appeared in this case, your lordship.
Delay control, neither AD received nor answered notice in respect of respondent number 4 has been received.
My lord, this regarding respondent number 4, there is a technical problem, my lord.
What?
This department does not exist as of today, my lord.
Which department exists?
My lord, now this will fall within the realm of, my lord, social justice and empowerment.
And you are appearing for that.
No, my Mr. RM Das, my friend RM Das is there, my lord. He will appear. I was the standing counsel for this department WPTBC once, my lord. Now it's no more.
This welfare of plain tribes have now been abolished.
My lord.
And which is the social welfare department?
Now social justice and empowerment, my lord.
Social justice and empowerment. And if that Mr. Das is appearing, then call him. I'll direct him to get the notices out.
My lord.
To accept the notices.
My.
And in the meantime, you filed a amended cost item. Yeah. The net concept of the applicant has made a oral prayer to implead the director of the Social Justice and Empowerment Department as a respondent to substitute the director of welfare, social justice and empowerment department in place of the existing respondent number 4. Full stop. The oral prayer made by the counsel for the applicant is allowed. She is allowed to file amended cost title within a period of 1 week. Full stop. It is informed that Mr. Das is appearing for the
Social justice and empowerment.
Social Justice and Empowerment Department. He direct to accept notice on behalf of the substituted respondent number 4. Miss this IA after 10 days while showing name of Mr. Das as sponsor for the respondent.
Item 18.
May I please, your lordship? Your lordship, as per the office note dated 21/5/2024, your lordship, your lordship, neither AD card nor unserved notice has been received back by the concerning section.
For respondent number 4 and 5.
Yes, your lordship.
Madam, you are appealing for respondent.
No, lordship, I'm appearing for respondent number 1, 2, and 3, your lordship.
Yes. Await return of notice of respondent number 4 and 5 for 3 more weeks.
Much obliged, your lordship.
Item 20.
May I please, your lordship? Lordship, the IA is for condonation of 14 days delay. As per the office note, lordship, service report is awaited.
Await return of notices of the respondent for 3 more weeks.
Obliged, lordship.
Item 21.
Lord, in this case, we have taken steps on 9/5/2024, my lord. Service is everything.
Same order, await return of notices for 3 more weeks.
Item 22.
May I please, your lordship? I have for condemnation of delay for 14 days, your lordship.
For the first time it is listed.
Yes, your lordship.
Issue notice of the IA number so and so returnable also.
Obliged.
Item 23 to 25.
Mr. Majumdar, in the identical appeals, we have already issued notices and stay order is also there.
Yes, and possibly stay order is not there. On the last occasion, the other side took time. This one was first time he said. After the roof casting of the first floor, they have come and they have, but it's a degree, model degree college for the, in the interest of the people.
That's right, but third go, I think so, in some of the cases, next date is 3rd June.
Not very sure. Hard been for different.
Some counsel appeared in the morning and he placed for an adjournment, list on 3rd of June. No present on behalf of the appellant, list on 3rd of June.
Let it be on 6th, madam. 6th of June.
Yeah.
6th of June, madam.
No, oh, Mr. Counsel,
23.
25.
Yeah, 23.
I'm sorry, my lord. May I please, your lord? Item 23, 24, and 25.
yes,
Identical issue, and the other issue, my lord, other matter has been fixed on, my lord, 3rd of June, 2024. So let this matter be posted on the same day, my lord. That will be convenience for.
at the request of the appellant, list this matter on 3rd, list these matters on 3rd of June along with the connected, along with the identical appeals. Yes.
Obliged, lord.
Item 26.
My pleasure. My lord, my nomination to the post of president of the school that was challenged by the writ petitioner on 2 my lord grounds. That at the time of nomination, I was holding the post of assistant teacher in another school and also
Assistant
teacher in another school. And also that I was holding the post of vice president of the school managing committee of another school. So under the notification of my lord, prevailing of 2016, that cannot be done. And to that effect also relied on the order.
On this ground, your, this, presidentship has not been cancelled.
Exactly, my
It
lord.
was cancelled on
honorable
the
civil
ground
judge-
that you are,
That earlier
earlier in the year 2018,
18,
you were appointed and that has been cancelled since you are
Political
affiliated with- yeah.
having political, but that is not the pleaded case of the my lord, writ petitioner. And nor my lord, the pleading were to that effect. And now, but then my lord, the honorable single judge having my lord, gone through the order of the 3/3/2018, it has been said my lord, that the earlier occasion also the secretary has held that I am having.
Since you were not eligible on earlier occasion, how now you are eligible for being holding that post?
Yes, my lord, But for the ground that, my lord, by 3/3/2018,
Yeah.
the secretary did not, my lord, rejected my claim because I am having political career. Rather, my lord,
This is what the Leonard Single judge observed, para number this
exactly,
internal page 7,
exactly. Lordship,
internal page 7 of the judgment.
Lordship, my lord.
It is there now.
Now, if your lordship looks into the, my
Mr.
lord, that particular order
Rukum
itself.
is said to be an active political worker. Rukumuddin Ahmad, his own statement stated that so and so. The guidelines issued constitute as the laid emphasis on non-political management committee of the secondary school. Criteria stipulates person considered for the post of repute and beyond any doubt and suspicion should not be a serving teacher.
No.
So on this ground only,
Lordship.
your earlier order was appointment order was cancelled.
Cancelled.
And
But
again, you
this-
were appointed.
But this is not the ground on which, my lord, the order dated 3/3/2018 was passed.
This is what the order, sir.
That this is the finding, my lord, the finding of the honorable single judge. The order dated 3/3/2018 itself is at page 105. This finding of the honorable single judge in reference to the order dated 3/3/2018 passed by the secretary.
Sir.
Now, if you also looks into the order dated 3/3/2018,
Where is that order?
is at page 105.
Yes.
Yes. No, 105, last paragraph, my lord. Having heard all the parties concerned and on perusal of all records and evidence, along with the report of the inspector of schools and the appointment letters issued, it is observed that it is a matter of dispute arising in the year 2016. During that period in the year 2016, it is clearly understood from all available records and submission that the Rukumuddin Ahmed, the petitioner in WPC number so-and-so claimant to the post of President SMDC of Dogaon High School, Dogaon, was serving as assistant teacher in Ali Kasimi Ansalik Higher Secondary HS. Records also indicates that he was an HSLC examiner in 2016. Rukumuddin Ahmed continued to be a teacher in the year 2017 as per certificate furnished by headmaster of Ali Kasmi Ansalik HS. The report of the inspector of schools Nagaon dated 17/1/2018 also indicates the same in respect of Rukumuddin Ahmed, that is the present appellant. Further documents, media reports and submission made by the complainants against the petitioner indicates unsubstantiated allegations of anomalies upon Rukumuddin Ahmed in the year 2010. Rukumuddin Ahmed is said to be an active political worker. Rukumuddin Ahmed in his own statement on 17/1/2018 stated that his candidature has the support of AIDF and BJP public and political representative respectively. The guideline dated 24th June 2016 and the letter dated 7th December 2016 issued to constitute the SMDC clearly laid emphasis on a non-political management committee in secondary school. Criteria stipulated that the person considered for the post should be of repute and beyond any doubt or suspicion and should not be a serving teacher. Allegation, now this is important, my lord. Allegation against Rukumuddin Ahmed, although not substantiated, an incident of protest that followed makes him vulnerable to suspicion and doubts and hence
Suspension. Vulnerable to suspension.
suspension. It should have been perhaps, my lord, should have been suspicion and
Yes.
doubt and hence his reputation though cannot be questioned, but he's invited controversies. So these are, my lord, cannot be questioned, but reputation though cannot be questioned, but has invited controversies. During the year 2016, that the year of appointment, Rukumuddin Ahmed has been a serving school teacher, which clearly violates the stipulated in guidelines in the letter dated so-and-so issued by the government that bars a serving teacher to be president of SMDC.
And
This very paragraph, allegation against Rukumuddin is beyond question. That has been escaped the notice of the Honorable Single Judge, and thereby, on the premises of the previous paragraph, which is only the allegations
yeah,
that he is having he is active political worker. But the notification says to be barred for holding the post is that one should not be contesting any of the election of panchayat, assembly constituency or parliamentary constituency in last 20 years. That is the mandate
this
of the
order is of January 2024. This improved order is of January 2024.
25th January, Lordship, my lord.
And the learned single judge has directed that this proceedings for appointing new president of the SMDC be completed within a period of 2 months.
2 months.
What happened?
We have no intimation regarding that.
At least if the new president has already been appointed, then what remains in this?
No, my lord, to our instruction, no one is appointed because
Your instructions are complete or not?
complete, my lord. Complete, my lord.
So the process for appointment of the new president has not been completed.
Not been
Has not been undertaken.
undertaken. But because of the election, my lord, it has not been proceeded, it seems.
Either you file an affidavit of this effect, otherwise we are not going to entertain. Okay.
Yeah.
While setting aside the appointment of the petitioner as president of the concerned SMDC, Learned Single Judge has directed the respondents to conclude the process of appointment of new president within a period of 2 months. Stop. It is noticed that the improved order is dated 24th of January 25th of January 2024, and since then 2 months have already been passed. Stop. Learned counsel for the petitioner is directed to file an appropriate affidavit informing that whether the proceedings for electing new president to the concerned SMC, School Management Committee. School Management Committee has been concluded or has been undertaken or not. Stop. List on. Kal dete hain affidavit. You file it tomorrow. List on 29th. 29th.
This is SMC or SMDC?
But somewhere it is referred SMDC, somewhere SMC, my lord.
SMC, School Management.
Obviously.
And by the way, earlier you applied for this presidentship of School Management Committee of some other school. And now you applied for a new school.
No, my lord, that was in 2018. I was holding the my lord, post of assistant teacher, as well as I was the vice president of another different school, my lord. Dogao high school. So therefore, 2000
School Management Committee persons should be of that area only.
of that area, my lord.
So you belongs to which area? But you filed an application in another school and thereafter.
No, we normally, my lord, the candidate do not, my lord, file. It is the recommendation goes from the, my lord, the principal of the college concerned, my lord. Then it goes to the inspector. Lordship, right, fine. Obliged.
Item 27.
My lord, I am for the sole respondent. I have been served with a copy, my lord, I am there for the sole respondent.
Mr. Consul,
My lord,
what's wrong in the order of the Learned Single Judge?
Single judge orders, I'm before your lordship, my lord, against the order dated 7/3/2024, page 232.
Yeah,
My lord, for impugn order at page 332,
yes,
232,
yes,
and para relevant column, para 234, my lord. Para
3, 4, yeah,
234, para, my lord.
yes.
In this writ petition, challenge is to the denial of release of the increment found to be payable to the petitioner. The petitioner claims to be entitled to increment payable to the petitioner. The said increment was not released as the disciplinary proceeding is in process and the matter is presently pending before this court. This was informed to the petitioner by communication dated 7 December 2022 of the writ petition. The counter affidavit has been filed by the Department Institute, wherein there is an avowal that the petitioner is not entitled to the increment for the period 1st July 2019 to 30th June 2020. The increment on 1st July 2020, however, was released provisionally. The learned counsel for the respondent has not been able to refer to any provisions of law and the rules were impose the authority to withhold an increment which is an employee is entitled to get under law on the ground that the department proceeding is pending and oblique or due to the pendency of a matter before this court of law. This is no order of this court directing the respondent not to release the increment stated to be payable to the petitioner. Insofar as the entitlement to increment is concerned, what is necessary to be seen is whether the employee fulfill the requirement of the relevant period of service. Office memorandum dated 12/9/2022 reflects that except for the condition mentioned under Office memorandum dated 18/2/1986, qualifying service of less than 6 months on account of EOL between 1st of July 2020 of the previous year till 30th June of the year. Under consideration shall have the effects of sending the increment to 1st of July to next year. However, from the facts available by my lord, this court is saying that nothing is notwithstanding the period of absence without leave alleged against the writ petitioner and which is the subject matter of the disciplinary proceeding, the petitioner otherwise become eligible for her increment in terms of the relevant office memorandum. Such position, in fact, is not disputed by the learned counsel appearing for the respondent. If that we show, then unless there is a specific order passed by the authority giving a reason for withholding the increment, mere pendency of the disciplinary proceedings and a pendency of any matter challenging the matter said disciplinary proceeding before court of law cannot be accepted to be a valid ground for denial of increment payable to the petitioner. Under such circumstances, my lord, under such circumstances, the Honorable Single Judge directed the authority to pay and release and pay the increment. And on the other hand, my lord, the respondent filed an writ petition before this court challenging the appointment of PO. That was dismissed by this court. And
That was the disposed of since the EO was already changed.
judgment is passed on a wrong office memorandum. This is the office memorandum. There is no pushbar regarding increment, my lord. That is, the order was passed on the basis of office memorandum dated 18 February 1986. The order was passed on the basis of the updated increment with regard to at page 203, my lord. 203.
Yeah.
203.
203.
203 page.
Yeah, 203.
The honorable court relying on para 4, my lord.
Yeah.
Except as otherwise, under condition laid down in this department's office memorandum number 7 dated 18/2/1986, qualifying service of less than 6 months on account of EOL without medical certificate between 1st July of the previous year till 30th June of the year under consideration shall have the effect of postponing the increment to 1st July of the next year. The same stipulation will also be applicable to those cases where the increment become due on 1/7/2006 in terms of the department's office memorandum dated 18/1986. EOL granted for the following purpose automatically count as qualifying service for pension and for increment without any further sanction. EOL granted due to the inability of a government servant to join or rejoin duty on account of civil commission. And EOL granted to a government servant for prosecuting higher technical and scientific studies. But the learned single judge has not considered the clause para 3, my lord, of this para 3. Consequence of the implementation of CCS Rule 2008, increment in the revised pay structure are to be regulated in terms of Rule 10 of the CCS RP Rule 2008. This rule states that there will be a uniform date of annual increment, namely 1st of July every year. Employee completing 6 months and above in the revised pay structure as on 1st July will be eligible to be granted the increment. That those persons who were appointed or promoted, or obtain increment under MSCP, the qualifying service for that person is 6 months, and thereafter 1 year.
Mr. Consul, just show us any office memorandum which mandates that if a person is, if an employee unauthorizedly absent from the duties, or if any disciplinary proceedings pending against an employee, then this increment, he is not entitled for any further increment. Where is that office memorandum? Because your stance before the learned single judge that this lady was not granted increment because the disciplinary proceedings were pending against her.
Yes, my lord.
Show us any office memorandum which mandates that if disciplinary proceedings are pending, no increment would be payable.
My lord, gazette notification, the honorable civil judge has not a gazette notification 208, my lord.
Where is that?
208, my lord.
208.
Page 208.
Yes.
This is gazette notification, 25th July 2016, and next page, my lord.
2016,
my lord.
16.
And gazette notification 2008, 208, page number 208. And at the next page, my lord, 209, 11.
209, read the provision.
That date of 10, plot 10. Date of next increment in revised pay structure. There shall be 2 dates of grant of increment, namely 1st January and 1st July of every year instead of existing of 1st July. Provided that an employee shall be entitled to only one annual increment either on 1st January or 1st July, depending on the date of his appointment, promotion, or grant of financial obligation. To my lord, the increment in respect of an employee appointed or promoted or granted financial obligation, including obligation under modified assured career progression scheme during the period between the 2nd day of January and the 1st day of July, both inclusive, shall be granted on 1st day of January, and increment in respect of an employee appointed or promoted or granted financial obligation, including obligation of MSCPS during the period of 2nd day of July, 1st day of January, both inclusive, shall be granted on 1st July. And next illustration is there, my lord.
Yes.
Therefore, illustration is there. In case of an employee appointed, promoted in the normal hierarchy of or under MSCP during the period between 2nd day of July 2016, the 1st day of January 2000, the first increment shall accrue on the 1st day of July 2017. And thereafter, it shall accrue after 1 year of annual basis. That there should not be any lapses or service breaks. And there, my lord, and the clarificatory office memorandum at page 237, my lord.
Yes.
The office memorandum is sold by the Ministry of Finance. And next page, my lord, para 5.
Yes.
Accordingly, keeping in view of the principle followed during the period before 1/1/16, immediately prior to coming into force of the CCSRP rules 2016, which has been modified in the revised pay structure in terms of Rule 10 thereof by way of the 2 dates of increment on 1st July and on 1st January and 1st July. It is clarified that in case an employee is promoted, granted financial obligation, including obligation under MSCP scheme on 1st January or 1st July, where the pay is fixed in the level applicable to the post on which promotion is made in accordance with the rules 13 of the CCSRP rules 2007. The first increment in the level applicable to the post on which promotion is made shall accrue on the 1st July or 1st January as the case may be, provided a period of 6 months qualifying service is strictly fulfilled. The next increment thereafter shall however accrue only after completion of 1 year. That is the next, my lord, consider instruction or next page, my lord.
Yes,
Next page, my lord.
yeah,
Consider it is a clarification also.
yes,
Instruction, regulation on
yes,
the para 5, my lord.
yeah,
At page 240. The
yes,
consequence and procedure to be followed in respect of an officer who is absent from duty without any authority has been brought out under FR 17 and 17A. As per FR 17A3, without prejudice to the provisions of Rule 27 of the Central Civil Service Pension Rules and 70, remaining absent without any authority or deserting the post shall deemed to be a cause and interruption or break in service of the employee under unless otherwise decided by the competent authority for the purpose of leave table concession, permanency and eligibility for appearing in the departmental examination for which a minimum period of continuous service is required. 6 my lord. 6 my lord.
yes,
Controller and Auditor General have issued order that the period of absence not covered by grant of leave shall have to be treated as dies none for all purpose, namely increment, leave, pension. Such absent without leave which is stand singly and not in continuation of any authorized leave of absence will constitute an interruption of service for the purpose of pension unless the pension sanctioning authority exercises its power under Article 420 of the Civil Service Regulation. Now rules 27 of CCS pension rule. To treat the period as leave without allowance, the entire past service will stand forfeited. That's my lord. Then for better understanding, my lord, what is our problem? How to
for better understanding.
flow chart, my lord. Flow chart. This is the period of absence of the respondent 26/3/2022, 22/5/4.
Those disciplinary proceedings have already been culminated.
My lord, proceeding after the dismissal of the writ appeal.
Yeah,
My lord, the
proceedings are going on.
the authority requested him to appear before the DP.
So,
But
still the proceeding, she has been, disciplinary proceedings are still going on.
yes, initiated, but now he is
Not
on leave.
concluded. Not,
He is on leave, not cooperative to us. But
that's
he is
another thing. That's
he
another
is-
thing. Whether
medical leave.
disciplinary proceedings have been concluded or not.
Not my lord.
Not, still it is going on.
Going on.
Okay.
Here, my lord,
Yes,
DP is required to determine. First, authorize is claiming that he obtained permission. And
yes,
now authorized, then increment allowed.
yes,
And unauthorized, DP is required to determine, as per court, Supreme Court thought that, whether
yes,
it is willful or No.
Yeah.
Not willful. If willful, the service break and an extra an increment fulfilling service department he is not entitled for increment. And other is not willful. Two part, my lord, on medical ground, increment is allowed. And allowed and not medical ground and other
Yes.
circumstances, my lord, here
That's
not
all.
increment.
That's all.
We cannot pay the increment subsequent year. That is why how the increment is calculated.
Fine.
At page gazette notification, it is gazette notification 208, my lord.
Yeah.
208, it is clarified that
You already referred to it.
gazette notification is there, my lord.
Yes, you have
I have
already
not
referred.
gone through this.
You have gone through it.
My lord, this part is not gone through, my lord, this part. That how the mode of calculation of increment
Look here. This,
at para 9, my lord.
yes, this writ appeal is filed by the appellants being agreed with the order dated 7/3/2024 passed by the London Single Judge in WPC number 5622/2023. Full stop. The whereby the London Single Judge has allowed the writ petition and directed the respondents to forthwith release the increment payable to the respondent. Full stop. The respondent is working as this is working as nurse or what?
Nurse.
Staff nurse. My lord.
Staff nurse,
Holding of increment is a percent.
staff nurse in
LGBT hospital.
in LGBT hospital, Guwahati. Full stop.
Name is there in the portal.
The she was
My lord.
uh,
Holding of
this,
increment is a prescribed
this
penalty under the
bad.
government.
he is bad, Jaya, sir. Staff nurse in this also hospital, Guwahati. Full stop. Disciplinary proceedings were initiated against the respondent. And a charge has been leveled against him regarding unauthorized absence from duty. Full stop. During the pendency of the said disciplinary proceedings, the annual grade increments have not been granted to the respondent, and therefore she filed the writ petition before this court with the prayer to direct the respondents to release the annual grade increments. Full stop. The appellants have opposed the writ petition before the learned single judge on the ground that since the disciplinary proceedings are pending against the respondent, she is not entitled for the benefit of annual grade increments. The learned single judge, having heard the learned concept of the parties and after taking into consideration the office memorandums referred by the appellants, has come to the conclusion that the appellants have failed to point out any office memorandum or any provision of law which empowers the authority to withhold the increment which an employee is entitled to get under the law on the ground that a departmental proceedings in pending and or due to the is pending against the said employee. full stop. Learned counsel for the appellant has argued that the learned single judge has erred in observing in holding that on account of pendency of the disciplinary proceedings, the annual grade increments of an employee cannot be withheld. It is contended that there are circulars, there are office memorandums which clearly stipulates that if a employee is guilty of willful absence from the duty, she is not entitled for annual grade increments, and the period of absence from leave will be treated as DICE non. DICE non. Full stop. DICE non for all purposes, whilst increment, leave, and pension. Full stop. The next counsel for the appellant has referred to office memorandum dated 20th of June 2010 in support of the above argument. Full stop. Having heard the learned counsel for the appellant and after going through the office memorandum dated 22nd of June 2010 and other gazette notification, etc., on which the counsel for the appellant has placed reliance, we are of the view that neither the office memorandum dated 22nd of June 2010 nor any gazette notifications stipulates that a employee is not entitled for annual grade increment on account of pendency of departmental proceedings against him and her. Full stop. In case the charge of unauthorized absence is proved against an employee, then only the said period is liable to be treated as DICE non for all purposes, that is increment, leave, and pension. In the present case, the said charge has not been proved against the respondent till date on account of pendency of the disciplinary proceedings which has not been concluded. Hence, we are of the in circumstances, we don't find any illegality in the impugned order passed by the learned single judge. Hence, no case for interference is made out. Writ appeal is dismissed.
Item 28.
Excellent. 1 minute.
May I please your lord, my lord? In this case, my lord,
Which case?
the 27, my lord, and
That has already been decided. That's all.
Item 28.
Subject to what your lordship may say, the question for consideration in this case is whether a nominated member of a
Council.
the autonomous council, my lord, is a full-time employee of the council. And because of that, he applied in the year 2018. And he got the allotment on the basis of his land. And
Mr. Chaudhary, there have been cases earlier also on same issue.
On this issue, my lord, perhaps not, my lord.
Nominated member of autonomous council. The dealerships have also been cancelled. Maybe another company.
Another company, maybe I'm not aware.
Whether there is any judgment on this
No,
point.
not on this issue, I did not find.
But
Same,
this is the practice that you are awarding this dealership to the sitting MPs, MLAs.
No, my lord.
Yes.
It cannot be
There
given.
were hundreds of instances. It's very clear.
here, an elected member has already been given.
Whether it should be given or not. Yeah. As long as it is done uniformly. Yes.
My lord, so far your query regarding that, my lord, that MLAs and MPs are given, my lord. In 2000, my lord, there was a proposal to give to my lord the MLAs and MPs. And my lord, then there was some heated, my lord, debate in the parliament, and thereafter those were cancelled. In 2000.
2000 goes cancelled and those again that at the time that the government has cancelled all the
Yes.
in bulk. Then
Yes.
there was a Supreme Committee of the Supreme Court and they have examined that and then they recommended for cancellation of few of the petrol pumps and other all others are they were I mean to say that were okayed by that committee and then those are running.
I don't have inspect on that.
That is there.
In this case, in 2018, he applied.
Yeah.
And his family property was there, the land was there, he offered the land. There was draw of lots, and in the draw of lots, he was selected.
Well, ultimately,
22,
ultimately, it is their discretion. If they found that you'll not be able to spare time for this running the dealership, then how can that
But elected,
judgment of them or that decision of them can be questioned?
yes, an elected member of the same council has been offered a election. He has been offered.
He has been offered.
Yes.
And he's
He's running it.
same council.
Same council.
My lord, that we came to know from his, my lord, writ petition. Thereafter, my lord, that is being enquired.
That is being,
Enquired.
what happened to that?
Oh, my lord, that has not attained its finality yet.
In my finality means still he is operating the dealership and you have denied it.
My lord, that was concealed by that, my lord, petitioner, that person, my lord.
So you have cancelled this.
That, my lord, I have to take.
And
It
my lord,
was naturally
main thing-
cancelled because, my lord, this is contrary to the guidelines. And here is a case, my lord, when the
Even though if they contrary to guidelines, in one case you are allowing and in another case you are not allowing, then it's.
No, my lord, that I have to take instruction what has happened to that because show cause notice was issued. Show cause notice was issued to him,
Okay.
that person.
Then it concept for the appellant has submitted that the
Because he is not an employee, my lord, in any way.
just in that. Then concept for the appellant has submitted that the respondent IOCL has refused to grant dealership of retail outlet, that is a petrol pump.
Yes.
Retail outlet of petroleum products to the appellant on the ground that he is the nominated member of a autonomous council. It is submitted that, however, the other member of the same autonomous council was offered dealership and subsequently is also appointed as dealer of or a dealer of a retail outlet. Full stop. Issue notice. Learned Mr. M.K. Chaudhary, Senior Counsel, accept notice on behalf of the respondent number 1 and 2.
1 and 2.
Mr. So-and-so is appearing on behalf of the respondent number 3. Service of notice upon all the respondent. All the respondents is complete. Place this petition for hearing in the month of on 24th of June 2024. Stop. In the meantime, the counsel for the respondents may file their responses to the writ appeal.
There is an IAM status quo order was there. During the
In the meantime, status quo as it exists today shall be maintained till next date.
Item 29.
Please, your lordships. Lordships, here we have challenged the order dated 25/4/2024 in page number 91.
Your appointment as chairman and vice chairman has been cancelled.
Yes, president and vice president, we were selected by the deputy commissioner, and thereafter we were arrayed as respondents 5 and 6.
Recommendation from the school authorities, this is
Yes,
essential.
yes, lordship, that is our ground. Among many grounds, the primary ground is that because at that time, the school authority, the in chargeship of the headmaster was held by the IS himself. So therefore, at that time, there is no school authority.
IS himself.
Yes, because there is no permanent headmaster. In chargeship was held by inspector of schools. So that is our primary contention. Then when the school authority itself is IS, therefore the rules have to be understood in light of the situation.
From which date to which date this he was holding the charge of this school management?
Lordship, even today, he is holding the charge of the
There is
headmaster.
no school authorities are there.
No, only the recently academic charge is given to headmaster, but still.
Yes, Mr.
I'm only appearing for the deputy commissioner. This matter.
You are appearing for?
Deputy commissioner, my lord. Matter, my lord, relates to my lord education. And my learned friend, My lord, he is appearing for the department, standing.
Who is appearing for the education department? Yes, ma'am. Yes.
And lordships in the judgment also, there is.
Yes. Madam. You are appearing for the respondents. So what do you want to say? Madam, speak out. What do you want to say? You are reading the brief here. Why? What were you doing yesterday? You are not allocated to you. Who is the allocating authority? Who is the allocating authority? Your senior? Where is he? Issue notice. So and so is appearing on behalf of the respondent number 1, 2, and 3. Mr. So and so is appearing on behalf of the respondent number 4 service. Let notices be issued to the respondent number 5 and 6 only. Returnable on 24th of June 2024. Yes, that's all.
Obliged. Item number 30.
May it please your lordship. Lordship may kindly pass over the matter for today as my senior and the conducted counsel in this matter has some personal difficulties today, your lordship.
Ready.
Obliged, your lordship.
On the prayer of appellants. The request of the council for the appellant. Ready.
Item 34.
May I please?
Yes.
Yeah, please, my lord. My lord, in this appeal, my lord, we have challenged the order dated 12/7/2019 passed by the learned ITAT, my lord. My lord, what was happened, my lord? In this case, my lord, initially SSA filed returns, my lord, and thereafter he filed.
The substantial question of
Lordship, we have proposed in my lord, page number 7, my lord.
Yes, you read, which is the best substantial question of law as per you, please mention.
My lord,
These are the substantial question of law.
my lord, lordship, what was happened, my lord? My lord may see
What
the
happened? You just
number 1
point
in
out
lordship.
one
Lordship.
substantial question of.
Number 1 and 2, my lord, whether on the facts and circumstances of the case, the honorable tribunal was justified in law in holding that the commissioner of income tax has erred in invoking his revision jurisdiction under section 263 of the Income Tax Act without at all considering an issue on which the assessing officer has made substantial addition following directions of
This is the
commissioner.
substantial question of law, then it's okay. This is the substantial question. Next.
My lord, next, my lord, number 2, whether the honorable tribunal is justified in law in condoning the delay of 1,782 days and admitting the appeal without having any evidence affidavit of a person who is said to be responsible.
This is again question of law. And next.
Lordship, next is general in nature, my lord.
So all these are general in nature. These are the grounds in fact. That can't be a question of law.
Lordship, my lord, there. My lord, may I submit, my lord? My lord, against, my lord, this order, my lord.
Point out the substantial question of law. We
Lordship.
can, at least we can frame.
Lordship. Lordship,
Have we gone through the order? We don't find any illegality, no substantial question of involved in this petition.
because, my lord, there are, my lord, two sets of litigations, my lord. Initially, my lord, what was happened, my lord, against the order passed by the assessing authority, my lord. The revision order was passed, that was challenged, my lord. In that revision order, my lord, it was challenged only on the ground that the initially, my lord, the CIT has passed an order, my lord, authorizing the Joint Commissioner of Income Tax to make an assessment, my lord. Subsequently, which was carried out by the Assistant Commissioner, my lord. So, my lord, in that was remanded, my lord. Against that also, they preferred an appeal, my lord. And by this common order, my lord, that the revision order that has been set aside, lordship. And my lord, we filed a separate appeal, my lord, for against that particular portion, my lord, for the first round of litigation. And this is the, my lord, second round of litigation, my lord. After, my lord, the fresh assessment order was passed by the Assistant Commissioner, my lord. Against the, my lord, the Commissioner has passed the revision order, my lord, by setting aside the, my lord, the order passed by the Learned Assessing Authority, my lord.
Can't be, the second assessment can't be done.
My lord, that was set aside only on the ground that no proper inquiry has been conducted by the assessing authority, my lord. So, my lord,
Based on facts, sir, whether there is any prohibition that he can't do that.
no, my lord, that the remanding back by the, my lord, the CIT, my lord. Lord,
Mr. Chetia,
lordship,
you see, these matters are to be admitted and heard on substantial
Lordship.
questions of law.
lordship,
First of all, out of the three questions, two are definitely not substantial question of law.
my lord,
Third could be,
my lord,
perversity is a question of law,
my lord,
could be.
my lord,
But you have to show us how this question arises in this case.
my lord,
Straight away come to that and convince the court.
my lord,
that's
may
all.
kindly see the, my lord, last portion, my lord, for,
Last
lord-
portion of what?
my lord, the order passed by, my lord, the appellate tribunal, my lord, that is, your lordship will find the relevant portion at page number 100, my lord.
What do you mean when you say perverse?
My lord, because, my lord,
What is the meaning of perverse according to you?
my lord, purpose is, my lord, something, my lord, which is not, my lord, as per, my lord, the provisions of the law,
Not
my lord.
based on evidence or
Yes, my lord.
misleading of evidence.
My lord, it was not, my lord, concluded, my lord, based on the evidence, my lord. Therefore, my lord, it was direction was
Sir,
issued.
the
my lord.
perverse,
Lord.
any order, if you are claiming that it is perverse, then certainly you have to demonstrate that it is not based on any evidence or misleading of evidence.
My lord, that is reflected in paragraph 18, my lord, at page 100
Yes,
of the order passed by the learned IT 18.
yeah.
We make it clear that the factual position hearing is no difference since the jurisdictional CIT had authorized the Joint Commissioner of Income Tax to frame the regular assessment in SS's case, which in turn was finalized by the Additional Commissioner of Income Tax. We adopt the above extracted reasoning to conclude that the impugned assessment has been framed by an assessing officer not having jurisdiction as per the CIT's order passed under section 124 of the Act. The same is declared to be honest in the eye of law. We accordingly conclude that CIT has erred in revising an invalid assessment not framed by the competent assessing authority. We accept the assessee's argument challenging the validity of CIT's revisional jurisdiction in impugned assessment year 11-12 therefore. My lord, for a moment,
Perverse about this.
my lord, for a moment, my lord, may see section 228C of the Income Tax
Mr.
Act.
Chetia, please, do you understand what is the meaning of perverse?
My lord, my lord.
If you don't, because you are constantly arguing something which has nothing to do with perversity.
My lord.
If an illegal order is not perverse.
Lord.
And you have not raised any question of law pertaining to legality.
Lord.
Therefore, conclude so that the bench can pass an order.
My lord, for a moment, my lord, for a moment, my lord, the conclusion of the learned, my lord, IT, my lord, that it's the jurisdictional error since, my lord, the order.
Sir, this para 18 only says that the earlier order of this, whatever the authority, they have followed that order and nothing else.
My lord, for a moment, my lord, my lord, may see section 29, section 2 subsection 28C of the, my lord, Income Tax Act, my lord, which says, my lord, define the joint commissioner, meaning of joint commissioner. On this score, my lord, it was, my lord, lordship set aside the order of the, my lord, CIT, my lord. It speaks, my lord, joint commissioner means a person appointed to be a joint commissioner of income tax or additional commissioner of income tax under section 1 of section 117. So, my lord, the authority conferred to the joint commissioner, my lord, by the commissioner to conclude an assessment proceeding that was carried out by an additional commissioner, my lord, that is sufficient compliance of the state order, my lord. On that score, that cannot be, my lord, set aside by the, my lord, learned, my lord, IT-80, my lord. That is my humble submission, my lord. That is perversity, my lord. That was not, my lord, reflected in, my lord, my substantial question of law, my lord. My lord, my lord, we propose this, my lord, a fresh substantial question of law, if your lordship may allow to place it now.
Just.
Because on this ground, my lord, the appeal was, my lord, allowed, my lord, by the CIT, my lord.
This additional commissioner has also been defined
Yes, Lord.
in the rules.
My Lord, yes, Lord.
That is section 2.
My Lord. My Lord, section 2, subsection 28C, Lordship.
28C.
My Lord. My Lord, it defines joint commissioner means a person appointed to be a joint commissioner of income tax or an additional commissioner of income tax under subsection 1 of section 117.
And the additional commissioner has separately been defined.
Yes, my Lord, yes.
That is
Lordship.
section 2,
1C.
228,
1C.
1C.
Yes.
My Lord, 228C.
1C, additional permit.
Additional commissioner will be included in paying commissioner, includes most of them. That is Let the board was justified and not. Income tax. Income tax. Then. Includes additional.
Hello, authorities are defined under section 116.
Just a minute.
No.
Madam, you are referring to the definition of this additional commissioner?
My lord.
Additional commissioner has also been defined.
Yes, my lord.
Where is that?
That is 128, 1C.
One?
No. Section 2.
228, 1C.
No, not 28. Section 2, subsection 1C.
Section 2.
Subsection 1C.
1C.
Additional commissioner means a person. Same. This assessment was done by invoking the power under section
143.
120.
Yes.
No, my lord,
Yes. 143, lordship.
assessment was done under section 143, my lord.
In exercise of powers of
My
section
lord.
120 for read with the income tax. 120, lordship, it was done under 124B, read with section 122, lordship, subsection 2. And lordship may also kindly take up section 120, lordship, which says,
Assessment 143.
no, lord, under 143, but the power that was exercised, that is under section 124, subclause B, read with section 120, subclause 2, lordship. And
120.
120. Section 120, if my lord takes for a moment, my lord, that defines the jurisdiction of the income tax authority.
Just a minute. 120.
120.
Yes, jurisdiction of the income tax
Yes,
authority.
this section says specifically that the authority may exercise the power, but the board has to specifically give them.
Which clause you are referring to?
4, lordship, subsection 4. Lordship.
Without prejudice to the provisions of subsection
Subsection
1
1 and 2, the board may by general or special order and subject to such conditions, restrictions or limitation as may be specified therein, authorize any principal director, director general or director to perform such functions or any other to the assigned to him by the board. Empower chief commissioner or Chief Commissioner or Commissioner to issue orders in writing that powers and functions conferred on, or as the case may be, assigned to the assessing officer. This paragraph says, Lordship, that they may function, but it has to be an order by the board and a specific order, which was not given to this additional commissioner of income tax. The power was given to joint commissioner, my lord.
Where is the board's order?
Board's order is not there, lord, with them. They have to show the board's order. Board's order is not there with them.
Yes.
My
Where is
lord,
the
may-
board's order?
My lord, may I submit, my lord? This, my lord, power under section 124, my lord, that is for issue directions, my lord. And as per this, my lord, as per this,
24?
my lord, section 120, subsection 4, my lord. This empowers the authorities to issue directions. And under these provisions, my lord, directions was issued by the commissioner, my lord, by assigning joint commissioner to make an
Sir,
assessment.
without prejudice to the provisions of section 1 and 2, the board may by general or special order and subject to certain restriction and limitation specified therein authorize any.
My lord,
So empower this persons or classes of persons to income or seize classes of persons shall be exercised and performed by an additional commissioner, an additional director, or a joint commissioner or joint director, and where any order made unless clause so and so. You show us the order of the board which authorizes the additional commissioner.
my lord, what my lord, I am submitting, I may be wrong, my lord, what I am submitting, lordship. These powers, my lord, these powers authorizes the, my lord, commissioner of income tax, my lord, to pass appropriate order, my lord, for the assessing authorities, my lord, for a,
Commissioner,
my lord, may, for a moment, my lord, may see subsection B, my lord,
yes,
subsection
read.
4B.
Yes.
Empowered the principal director general or director general or principal chief commissioner or chief commissioner or principal commissioner or commissioner to issue orders in writing that the powers and functions conferred on or as the case may be assigned to the assessing officer by or under this act in respect of any specified area or person or class of persons or incomes of or classes of incomes of the case or classes of cases shall be exercised or performed by an additional commissioner or an additional director or a joint commissioner or a joint director. So, my lord, this power, my lord, for issuing direction by the commissioner, my lord. And
so commissioner has authorized this additional commissioner to
joint commissioner, my lord, not additional commissioner, my lord.
joint commissioner.
Lordship.
And this assessment was done by whom?
Additional commissioner, my lord.
How can it be, sir?
So,
where is that? Where is that order of the commissioner?
Yes, my lord, that is not on record, my lord. That is not on record.
You should have places on record,
Lordship,
sir.
lordship. It was filed, my lord, long back, my lord.
Whatever it may be, sir. Then we don't. We are not going to entertain after consuming so much of time. We are not supposed to. Okay.
My lord, my only perversity is, my lord, may see subsection 28C, my lord.
Yes, read.
Section 228C, my lord.
Yes.
It says, my lord, joint commissioner means a person appointed to be a joint commissioner of income tax or an additional commissioner of income tax under subsection 1 of section 117. So, my lord, joint commissioner also include additional commissioner, my lord. That is my humble submission.
That's all. That's all.
My lord.
Okay. This income tax appeal is filed by the appellants being agreed with the order dated. Which is that order?
Yes, my lord.
Impugned order is?
My lord, the impugned order dated 12/7/2019, ma'am.
Page?
Lordship, page, my lord,
Page 50 in my
72, my lord.
72. Being agreed with the order dated
12/7/2019.
12/7/2019 passed by the Income Tax Appellate Tribunal Guwahati Bench, Guwahati. whereby the appeal filed by the appellant, filed by the respondent has been allowed and the assessment order passed by the and the order passed by the Chief Income Tax Commissioner under section 120 in bracket 4 of the Income Tax Act has been set aside, whereby the CIT has revisited an invalid assessment order passed by the Additional Commissioner of Income Tax. Full stop. The income tax, the ITAT has concluded that the joint commissioner, that the additional commissioner of income tax was not the authorized officer, but was not authorized as assessment officer, and only the joint commissioner of the income tax was the can pass the assessment order. Full stop. The Income Tax Appellate Tribunal has placed reliance on the decision of the Delhi High Court passed in CIT versus Pawan Kumar Garg in bracket 2011 bracket close 334 ITR 240 in bracket Delhi. Full stop. Having heard the learned counsel for the learned counsel for the appellant has submitted that as per the definition of joint commissioner as provided in section
Section Lordship 228C, my lord.
228C,
That defines the joint.
the additional commissioner includes, the joint commissioner includes additional commissioner, and therefore the ITAT has added in setting aside the Chief Income Tax Commissioners, Chief Income Tax CIT's order dated CIT's order. Full stop. It is to be noticed that the Delhi High Court in CIT versus Pawan Kumar has dealt with a similar issue in detail and has thereafter concluded that an additional director of the income tax cannot be treated as a joint director of the income tax. We are in perfect agreement of the decision of we are in perfect agreement with the decision of the Delhi High Court rendered in CIT versus Pawan Kumar Garg. Hence, we don't find any substantial question of law. If we don't find that any substantial question of law is arised in this income tax appeal, the same is therefore dismissed.
Item 45.
May it please your lordship. Your lordship may kindly peruse the last order.
Yes.
Your lordship may kindly peruse the last order dated 19/4/2024, my lord.
Yes.
Whereby instruction was sought, my lord. So, my lord, as per instruction, my lord, the appellant, my lord, since the honorable single judge has set aside the settlement order made in favor of the appellant, my lord, possession has not been given to him. So without possession, he cannot carry out the fishing, my lord.
No,
So he is not.
This government advocate has informed that fishery in question is running by you only.
No, my lord. Because without possession, I cannot run, my lord. It is the villagers, my lord, the local villagers, they are fishing, my lord.
Without there being any complaint.
Yes, my lord, because it is under dispute. So, my lord, neither of the parties are, my lord, fishing. So the villagers are fishing there, my lord.
Let the new, this tender be taken to, sir. We are not running the fishery. So prior to that, you were running the fishery.
Yes, I got the settlement order, but before getting the possession order, my lord, it has been set aside, my lord.
Although, my lord, there is no interim order in this writ appeal. My lord, due to pendency of this writ appeal, my lord, the authority has not issued the NID. Fresh NID.
You just tell us, whether this, your case was before the learned single judge that this tender was, notice was duly published. Mr. Consul, your case before the learned single judge, the notice was duly published.
Yes, my lord. Lordship may kindly see it. We have filed an affidavit in this writ appeal, my lord.
Yes. Page.
Page, my lord, 49, paragraph 4. Paragraph 3, page 48, my lord, first.
Yes.
That with regards to the statement made in paragraph so and so, department begs to state that NIT regarding Iraville fishery has been called by this office memo number so and so dated 12/8/2021 as per the instruction for retendering of the said fishery by the Deputy Commissioner Karimganj. The deponent further stated that the NIT against the said fishery has been called off earlier by this office memo number so and so dated 3/3/2020 and 17/11/2020 due to non-receipt of the minimum required number of tender, as there were no minimum required number of tenders. 3 tenders were required against the said fishery. The Deputy Commissioner Karimganj ordered for tendering the said fishery.
The other side is, the service of notice upon the other side is complete.
Yes, my lord.
Then no one is appearing.
My lord, so far as the private respondent is concerned, my lord, we have taken the notice by Dusty Service twice, my lord. But they refuse to accept, my lord. So we have filed affidavit also. my lord.
That notice, this, we have already treated the service of notice. I think so. The appointment we will get. Yeah. Then concept for the appellant has submitted that learned single judge has added, holding that there was no proper publication of the tender notice. Whereas the appellant as well as the counsel for the state has demonstrated before the learned single judge that the tender notice was duly published. Admit, issue notice. Mr. So-and-so put in appearance on behalf of the respondent number 1, 2, 3. Let notices be issued to the respondent number 4 only. Returnable 6 weeks. In the meantime, effect and operation of the order dated
26/8/22.
Improved order dated 26/8/2022 shall remain stay. The respondent number 1, 2, 3 are directed to hand over the possession of the fishery to the appellant within a period of 1 week if already not handed over. Alright.
Item 37.
May it please your lordship. Well, this PIL, my lord, there is another PIL also. So if your lordship take this PIL along with PIL 5 of 24, then my lord, the entire issue can be
In
decided.
that PIL, they have already filed an affidavit that compensation has been paid or what?
They have filed an affidavit. Bringing on records some material by
This
council.
along with
PIL 5 of 24 on next Monday, my lord.
file of 22, which is the date fixed in that PIL.
That PIL, no date has been given. Last listed on 8th of May, my lord. 8th of May
2024.
24.
There must be a date.
My lord, it was directed to release after 2 weeks.
It will be listed along with that. List along with so and so. PIL 5 of 2024.
24, my lord. Obliged.
Item 38.
May please your lordship. Look, this is an appeal preferred against an interim order passed by the single judge, my lord.
Interim order.
Yes, my lord.
Where is that?
Lordship will find the order at page 76, my lord. The appellant is basically aggrieved by paragraph 31, 32, and 33, my lord. Though it is an interim order, my lord, the entire aspect has been decided by the Supreme Court.
So whether he has decided that or not?
My lord, it is yet to be decided that the director has passed an consequential order pursuant to this order, my lord.
This order, interim order, he has already determined the seniority.
Yes, my lord, they have passed an order reverting me back to the post of my lord LDA.
And in that order you have challenged.
That order has been challenged. There is a stay order, my lord, in the petition.
So then what remains in this?
So, my lord, now, my lord, my prayer would be, my lord, let the single judge decide the petition, my lord, without being influenced by this interim order, my lord. Because, my lord, this.
Your reversion order.
Yes, my lord.
That is, you already challenged in separate proceedings.
Yes, yes, my lord.
So what remains in pendency of that, this petition also, writ petition before the learned single judge also?
That is, my lord, that is still pending. That is the only.
It is pending, but that has also been decided for all practical purposes.
Yes, yes, my lord. That is what, my lord, I'm, my lord, apprehending, my lord.
Yes, madam.
Lordship, some time to file reply, Lordship.
What reply? What do you?
Lordship, I have not completed half percent completed reply, Lordship. 21
Yeah,
can
you have?
for reply, Lordship.
Madam, for what?
To file reply, affidavit in reply, Lordship.
But
Lordship,
what do you want to?
my humble submission.
Why you want to file reply in the facts of the present case?
In this, there is no substantive law to promote this LDA to assistant teacher, Lordship.
So his promotion has already been cancelled.
Lordship, he is sent to revert back. That is not actually execute, Lordship.
that stay order is going on. For that reason, stay order in some petition, stay is operating therefore.
That's it.
So then what remains in this petition, madam? By the interim order, the court has directed, learned single judge has directed to decide the question of seniority between the appellant and the you. And he has already decided which is under challenge. Which is under challenge in a separate writ petition. Then what remains in this appeal as well as the petition?
Consequential order. And he has put it to challenge in a separate, and that is no live issues.
So look here. This writ appeal is filed by the appellant, being agreed with the order dated 22nd of February 2023, passed by the learned single judge in WPC number 1048/2019, whereby the learned single judge has directed the Assam directed the DSC,
Director of Secondary Education, madam.
Divisional
Director of Secondary Education.
Director of Secondary Education, Assam, to determine the question of seniority of the appellant vis-a-vis the respondent number 4 within a period of 60 days, 45 days from the date of, within a stipulated time. Stop. While issuing such direction, learned single judge has posted the writ petition number 1048/2019 after 8 weeks. Full stop. Learned counsel for the appellant has submitted that pursuant to the direction given by this court, the Director of Secondary Education, Assam, has already decided the question regarding the seniority of the petitioner and the respondent number 4, and being agreed with the same, the appellant and the respondent number 4 being agreed with the same, the appellant has preferred a separate writ petition before this court, which is pending adjudication. Full stop. Taking into consideration the fact that the question regarding the seniority of the appellant and the private respondent has already been determined by the Director Secondary Education pursuant to the impugned order passed by the learned single judge. We don't find any reason, we don't find any live issue in this writ appeal, and therefore no further order is required to be passed in the passed. Full stop. We also feel that since the question regarding the seniority of the appellant and the respondent number 4 has been determined by the Director Secondary Education, Assam, the writ petition number 1048/2019 is also infructuous. Has also become infructuous. Stop. In such circumstances, the writ appeal number 455/2023 and the writ petition number 1048/2019 be treated, be disposed of as infructuous. That's all.
What is the
Present
petition number?
pending writ petition, at page 49, WPC 6120,
However, the writ petition number, WPC number
6120
6120
of 2023, my lord.
of 2023 is required to be decided by the learned single judge on its own merit. Bas, without being influenced by the order passed by the without being influenced by the impugned order passed by the learned single judge, which is under challenge in this writ appeal.
Deeply obliged.
Item 39.
May I please, Judge? With referred to, my lord, mainly, my lord.
The last occasion,
My lord.
yeah.
That your lordship may kindly see the affidavit filed by me, my lord. When this, it was filed on, my lord, 15/5/24. Perhaps it is on the record, my lord.
On
15/5/24.
15/5/24. Yes.
Right.
Page
Page 127 is the type copy and the original copy at page 128. By which, my lord,
just
my lord.
Yes.
Lordship may kindly see the reference, your letter number, reference made in this letter, my lord, in this letter dated 11 December 2028.
Yeah, your reference number K.
Your reference number so and so dated 18/8/2007. This is the letter, my lord, that was communicated to the,
Where is that letter?
my lord. Page 94, my lord.
94.
In the appeal.
Ninety-four says,
My lord.
with reference to the above in continuation of the earlier order, I have honored to forward here with one proposal
My lord.
for compassionate appointment. But where is the rejection of this appellant's case?
My lord, page 96 is the statement made.
96.
Writ petitioner, my lord, Gautam Boro.
Yes, Gautam Bora has been rejected. A specified period has already been left during government instruction so and so. Whether application was within 1 year, so it's so. This you have sent along with this letter dated 18/8/2007.
Yes, my lord.
Four 6/2015. The details of the application for appointment under in different officers under Kamrup Metropolitan as per Honorable High Court order in dated so and so. ये तो 4/6/2015 है this order 96 page पे तो. Sir, what we remember, Mr. Consul,
My lord,
on the last occasion you said, wide, this recommendation dated 18/8/2007, you have recommended
my lord,
cases of 3 persons,
3%, my lord.
out of which one person was appointed, was granted this compassionate appointment by the concerned authority, and therefore it would be deemed that this order dated 18/8/2007 was served upon the joint commissioner or the deputy commissioner.
My lord,
This is what this was your case was.
my lord,
That you
your
have
lordship,
projected on
my
the
lord,
last occasion.
my lord, page 108, your lordship found that while my lord rejecting the case of the writ petitioner, my lord,
108.
108. 105 onwards, 105, 6 and 7 are the part of the minutes of the meeting, and
Yeah.
108 is the statement.
Yeah. What it says.
Name of the applicants recommended, my lord, Hemanto Taro and Sri Mukut Deka.
Yes.
Their case, while my lord rejecting the case of the writ petitioner Gautam Boro, the 2 persons' names were recommended to the state level committee as well as the finance department. Letter dated 18/8/2007.
Fine.
My lord, then my lord, while filing the review petitioner before the learned single judge, the finance department, by filing an affidavit, they have said, my lord, this letter has not been received by the finance department as well as, my lord, the state level committee. My grounds is that, my lord, while my lord not recommending the case of the writ petitioner, case of the, my lord, Shri Hemanto Taru and Shri Mukut Deka was recommended before the, my lord, state level committee as well as to the finalist department. And the Mukut Deka's case has been duly, my lord, considered by the state level committee, and he was appointed as.
You mean to say that the 3 persons were recommended for compassionate appointment by the district level committee to the state level committee,
My lord.
and out of which one was provided appointment.
Yes.
So now the question is, this 18/8/2007 letter was received by the finance commissioner when?
They have, my lord, they said, my lord, they did not receive the copy. My lord, when it was received, that I cannot say, but by referring the letter of the deputy commissioner, that is 18/8/2007, the case of the.
Who is to receive the compensation amount? 1 lakh rupees?
My lord, the petitioner. Petition.
Notice. Requisites be filed within a period of 1 week on filing of the same. Notices made returnable 3 weeks thereafter. In the meantime, the direction given by the learned single judge for depositing, for paying a cost of rupees 1 lakh to the respondent, while impugned order shall remain state.
Item 40.
My lord, in pursuance to the order dated, my lord, 19/4/2024, the missing autonomous council has to file an affidavit.
Additional affidavit, Mr.
Yes, my lord, we have received the instruction, my lord. We
too time to file affidavit. File an affidavit.
Again, and concept appealing for the missing autonomous concept. Raised for and granted 2 weeks further time to file additional affidavit in terms of the order dated 19/4/2024 passed by this court.
Item 42.
My lord, my senior is out of station, my lord, I pay for password for that. My senior is out of station, my lord, as well. I pay for password.
Done for 8 weeks.
Hello, please.
Item 44.
Wait, please, your lordship. Lordship, can you please the last order, lordship? The state was supposed to be.
Yes.
I've gone through the judgment.
Yeah.
Now your lordship passes this order in the nature of the order passed by the Honorable Supreme Court, and in future, of course, while making an appointment of special PP, public prosecutor.
Here he has challenged that.
Well, in fact, I'm not saying that this judgment will not be applicable here. What I'm saying is, my lord, earlier there was no such order by any court. So in terms of the provisions of the POCSO Act, my lord, the appointments were being made earlier also. There was no challenge on this ground that section 24 has to be followed.
But here this para 20 is very clear.
20 I've read. Now correct. That's the key question.
Yes.
Only
Who is for the private respondent? Single bench? What,
Registrator is
ground. Only this is the ground. What other ground? You just, have you gone through this judgment? And it's fairly covered. That is also. Yeah. Yes.
By notification in the official gazette.
Section?
Section 30.
Section 32. Application of this special public prosecutor. Yes.
The state government shall by notification in the official gazette appoint a special public prosecutor for every special court for conducting cases only under the provision of this act.
Fine.
And the person shall be eligible to be appointed as a special public prosecutor under any subsection 1 only he had a practice for not less than 7 years. So see, I have a practice of 40 years.
So that's
And
another
there
thing.
is a conscious decision by the government. So since the victims in POCSO, court lordship, they are mostly lordship minor girls.
Have you gone through that, this section 46 of the PML Act?
Section 46 lordship.
Section 46 of the PML Act, have you gone through?
Section 40.
Come at 2. Mr. Consul, go through section 46.
Yes.
Go through section 46 and come.
Section 46, that is the application of the Code of Criminal Procedure 19.
Read, and now compare it with the section 32 of the POCSO Act. And then come. At 2, after lunch, at 2, come.
Yes, Lordship was referring to section 46 of the Prevention of Money Laundering Act 2002, Lordship. Lordship, here, Lordship, from reading of the state section, Lordship, it is, shall apply to the proceedings before a special court. Save as otherwise provided in this act, the provisions of the Code of Criminal Procedure 1973, including the provision as to bails or bonds, and apply to the proceedings before a special court, and for the purpose of the said provision, the special court shall be deemed to be a court of session, and the person conducting the prosecution shall be the special court, shall be deemed to be a public prosecutor. Provided there are some provisions, and person shall not be qualified to be appointed a public prosecutor or a special public prosecutor under this section unless he has been in practice as an advocate for not less than 7 years under the union or a state requiring special knowledge of law. Lordship, here in my case, Lordship, I have 40 years of experience. Lordship. Now, this is a deeming clause, Lordship, but my appointment was done as per section 32 of the POCSO.
Now read section 32 together with section 31 and 32 together with section 46.
Lordship. Section 31, Lordship. Save as otherwise provided in this act, the provision of the Code of Criminal Procedure 1973, 2 of 1974, including the provisions as to bail and bonds, shall apply to the proceedings before a special court, and for the purposes of the said provisions, the special court shall be deemed to be a court of sessions, and the person conducting a prosecution before a special court shall be deemed to be a public prosecutor. And the special public.
Now read section 41(1).
41.
Subsection 1, section 46.
Save as, save as otherwise provided in this act, the provisions of the Code of Criminal Procedure 1972 of 1974, including the provisions as to bails or bonds, shall apply to the proceedings before a special court. And for the purpose of the said provision, the special court shall be deemed to be a court of session, and the person conducting the prosecution before the special court shall be deemed to be a public prosecutor.
Same. 41(1) is material to section 31. Now read subsection 2.
Yes, a person shall not be qualified to be appointed as a public prosecutor or a special public prosecutor under this section unless he has been in practice as an advocate for not less than 7 years under a union or a state
Here
requiring.
they have said practice advocate not less than 7 years.
Lordship.
That's all.
I have a practice of 40 years. Lordship.
That now the manner of appointment.
Not,
And this subsection two, subsection three of section 46 is perimeter to section 32.
Section 3 is a deeming clause, Lordship, because shall be deemed to be a public within the meaning of clause U of section 2.
Now, read the para 20 of the judgment of the Honorable Supreme Court.
From a perusal of section 46(1) of the said act, it appears that every person conducting prosecution is deemed to be a public prosecutor. At the same time, section 2U CRPC makes it clear that any person who is appointed under section 24 CRPC is a public prosecutor. Therefore, on a conjoint and harmonious reading of section 46, along with section 24 CRPC, it appears that the expression persons conducting the prosecution before the special court in subsection 1 of section 46 of the said act would mean that such a person must either be appointed by the central or the state government after following the procedure prescribed in subsection 4(5), along with subsection 7 of section 24 CRPC. Or in the alternative, after following the procedure in subsection 6, read with subsection 7 of section 24 CRPC, we are of the view that both the provisions, namely provisions of section 46 of the said act and section 24 CRPC must be read together. Since section 46 of the said act being a later act makes an express reference to the provisions of the pre-existing central law, namely the provisions of section 24 CRPC.
Now what remains?
Lordship, the section, then Lordship may kindly come to section 24 subclause 4 of the CRPC, which says the district magistrate shall, in consultation with the session judge, prepare a panel of names of persons who are in his opinion fit to be appointed as public prosecutor or additional public prosecutor for the district. Here, Lordship, although there is no consultation with the district magistrate, but here in this case, Lordship, the Bar Association has sent two panel of two names.
Yeah,
And the session
follow,
judge,
they have to follow the procedure prescribed under subsection 4, 5, and 7 of the 24 or section subsection 6. Whether that has been followed or not.
now if your Lordship comes to section 32 of the special court POCSO, that is very clear, Lordship, there is it has not been mandated that any consultation is required. It has been simply stated that Lordship, the state government shall by a notification in the official gazette appoint a special public prosecutor for every special court for conducting cases only under a provision of this act. So there is no consultation required, and Lordship the and it is not a case, Lordship, my name is not there. My name is also there in the panel list, Lordship. And Lordship, I have filed a detailed affidavit, Lordship.
Your name was not there.
My name is there, Lordship, in the panel list, Lordship. May I kindly see?
May please, Lordship. His name was Lordship in the list sent for the other post. Additional public prosecutor, not for the special public prosecutor.
My name is there, Lordship.
Where is that?
At page 30. Lordship comes to page 29, Lordship. Of the resolution, Lordship.
Page 28 and 29, two panels were sent, Lordship. On the same date, 22/5/2023.
The recommendation of the petitioner is?
In page 28, Lordship, it is for the panel of 3 advocates for appointment of special public prosecutor for the POCSO court.
Page
28, Lordship. Page 28. Serial number 1 is the petitioner, Lordship.
This is the Bar Association.
Yes.
Where is the this recommendation by the district judge?
District Judge has forwarded
This list was forwarded by the
before
District
the
Lordship.
LR Commission and Secretary at page
At
30.
page 30, Lordship.
Page?
Page
30.
30.
30. The first paragraph, Lordship.
Why these earlier newly appointed special public prosecutors have resigned? On 3/5/23, some special or additional.
Yes, has
Why they
resigned.
have resigned?
It's not. Reason is not known.
Reason is not wrong, Lordship. Probably.
And in this case, also the government has filed an affidavit. Their stand is very clear. Also. Paragraph 5.
They stand, they support you.
No.
No problem.
CRPC public.
The procedure that has been followed in this case, since there was no judgment earlier, that's
fine.
The procedure that has been followed is that the office, this panel sent by the district judge was considered and then appointment was made. And the stand we have taken in the affidavit is that although our name of number 7 was not forwarded for the purpose of special public prosecutor for POCSO. Her name was available and they considered her to be filled, that is how to other point. But if your lordship wants hold, then in terms of the judgment.
The district judge, section 24, subsection 4, you read.
That is what I want to point out. What I'm submitting well.
Yeah.
In terms of subsection 4, section 24, the call has to be taken by the district magistrate.
The district magistrate shall in consultation with the prepare a panel of name of the persons who are in his opinion fit to be appointed as so and so.
Fine.
No person shall be appointed respect government public prosecutor or additional for the day unless his name appears in the panel prepared by the district judge. So here no panel was prepared.
No. The stand is very clear. This, in terms of the judgment, there is no direction so far as Assam is concerned. That it has to be in terms of procedure prescribed in section 24. It was
Simply you appointed in this procedure that this bar association has made a request and then you have send it to the district judge. District judge forwarded the same. This is altogether a lower.
That is what I'm saying. In terms of this Supreme Court judgment, if your lordship now hold that section 24 of CRPC has to be followed, then the appointment of both of them cannot be considered.
Yeah, that's right.
And
no doubt about that.
And the procedures of
the procedure altogether a procedure as prescribed under this section 24 has to be adopted.
What's most aspect I have to point out by as your lordship has seen in section 24, section 4 says about consultation, and it is the district magistrate who shall in consultation with the session judge prepare the panel.
Yeah.
So district magistrate prepares the panel after consulting with the session judge, then the matter is forwarded to the government. For that matter, there is another judgment of our High Court, which is relevant because there in how a appointment has to be made on section 24 has been discussed. And the provisions of the Assam Law Department manual has been taken into consideration. Lordship may kindly have a look at the judgment 2021, volume 3, GLT, page 579.
Mr. Majumdar,
My lord,
before you proceed with the judgment,
my
there is one fundamental premise,
My lord.
which please tell us whether you agree or not.
my lord,
There is a clear procedure laid down under section 24.
my lord.
The panel has to be prepared by district magistrate in consultation with the district judge.
My lord.
Correct? Nobody whose name is not in the panel can be appointed by the government.
Yeah.
So government does not select. Government is to only act on the panel prepared by the district magistrate
District magistrate.
in consultation with the district judge.
Yes.
Correct?
Yes.
Government can choose one of the names from the panel
Yes.
at the most. Now, the private respondent's name was never recommended or never included in the panel for appointment of special public prosecutor. Obviously, that cannot be sustained. If it cannot be sustained, the next thing will be to follow the procedure and appoint someone.
And that's what I'm saying.
What else is there to argue in this case?
Well, that's what I'm not arguing. I'm not opposing what my learned friend is saying that the Supreme Court judgment should not be followed. What I'm saying is, my lord, since your lordships will now be passing an order based on which in future all such appointments will have to be in terms of section 24. I am just pointing out that another judgment of the Supreme Court, of course, single judge, which takes care of the manner how the section 24 of CRPC is to be followed.
Yes, sure.
Page 21, 2021, volume 3, GLT 579. And I had the opportunity to appear in that case also, my lord. Lordship may kindly turn to para 11 and then next page of para 11 at page 584, my lord.
Para 11.
Para 11.
Read.
Yes, it is seen that Law Department manual provides for appointment of government pleader, assistant government pleader, public prosecutor, additional public prosecutor, and assistant public prosecutor. The appointment of government pleader and assistant public pleader are made as per relevant rules under Part 1 of the said manual. The appointment of public prosecutor, additional public prosecutor, and assistant public prosecutor are made as per rules under Part 2 of the said manual. Thus, it would be appropriate to extract herein rules below rules 137 to 140 of Part 1, Chapter 10 relating to civil suit rules, as well as rules 1 to 15 of Part 2, Chapter 1 relating to criminal rules of the Assam Law Department manual. Now, next, Lordship, we can skip to the next page, my lord, page 584, the third paragraph, madam. From second paragraph onwards, it says criminal rules. Third paragraph says, my lord, 1A. Because under criminal rules says appointment of public prosecutors. Now, paragraph 1, we can skip, my lord, paragraph 1A, Lordship may kindly see. Appointment of public prosecutors. Lordship has got, my lord. Page 584 on the left-hand side, my lord. 584.
Yeah.
Third paragraph, my lord. Start from second, dealing with criminal rules. Then 1, we can skip. 1A, my lord, I'm reading. Appointment of public prosecutors. Whenever the office of public prosecutor is vacant, the deputy commissioner shall, in consultation with the session judge, nominate a qualified pleader for the appointment and submit the papers to the legal remembrancer, who shall forward them to the state government with his recommendations. The pleader selected will be appointed by the state government and will receive his deed of appointment through the legal remembrancer. This is the procedure, madam.
That procedure, we are not disputing that. The procedure which is provided.
But I'm only saying that when your lordship passes the judgment, this may be referred so that they do it in accordance with the relevant provision. That's what my intention is, only to show that
you want it to be in consonance.
Because today the judgment you are lordship passing today will have a lot of ramifications in all Assam. Whenever an appointment is made, this judgment will be followed.
Yes.
That is why I'm pointing out.
In fact, our Honorable High Court, the single bench has made some observation with regard to appointment of.
Observation in where? In case of appointment of whom?
By the provisions being similar, there is no escape from the judgment of the Supreme Court.
That's the only thing.
Paragraph 34 and 35.
Yeah. For what purpose you are referring to?
Lordship, the rules since there are no rules in place, Lordship, the Honorable Single Judge has made a request before the Honorable Chief Justice of Guwahati High Court to issue certain guidelines to the session judge for this purpose. Party
Rules for what?
for appointment as a public prosecutor.
Sir, the, you need to say the criteria.
Criteria.
The criteria is not the issue here. Procedure is the issue.
No.
Why are you bringing criteria here? Criteria is 7 years of practice.
And Lordship, one more division bench order, Lordship. Here it says, Lordship.
Yeah, what is it? What the division bench has held?
Division bench has held that so long as in the appointment of a councillor, the procedures laid down under the Code of Civil Procedures are followed and a reasonable or fair procedure is adopted, the court will normally not interfere with the decision.
But
The nature of the offence.
If the procedure would have been followed, we would not have interfered with. But since it has not been followed, we have to.
But it is the rule prevailing, Lordship. There is, all appointments are like this only, Lordship.
Now onwards.
Names are sent before the LR department and they appoint.
Now onwards, you have to follow the. Make your effort for sending your name and then get it approved from the government. Otherwise, government is also is in your favor.
Lordship, in fact, Lordship, in 2017 also, Lordship, he also he was removed and Lordship, I was appointed. At that point of time, he did not object, Lordship. Same procedure was followed.
Today,
That notification.
Ultimately, we are not issuing direction for appointment of him as a public prosecutor. We will simply say, follow the procedure and appoint any person. He, you, may, A, B, C, D, X, Y, Z. Order is there.
Only one submission, my lord. Till the fresh appointment is made, Lordship may allow the present incumbent to continue so that the work doesn't suffer in the POCSO court. This has been the observation in the single judge judgment also where I have.
Item number 4.
But, there are two, three issues, Malad. As regard the demarcation, Malad, I have taken the instruction. Malad, the Dipor Bill area falls under two circles, Malad, revenue circles. The Guwahati Revenue Circle and the Ajara Revenue Circle. Demarcation under Guwahati Revenue Circle has been completed. Ajara is not yet completed.
What about this filling of land, unauthorized filling of land?
Art filling, Malad, as per my instruction, Malad, the Deputy Commissioner has informed that art filling is not done on Dipor Bill area, Malad. It is on some patta lands. The contractor has filled up some art, and that needs to be used as Malad storage for the work or the construction materials. Malad, and my learned friend has also obtained some instruction that has Malad clarified that. That copy has been provided to you.
One copy of the instruction. The second page is the environment clearance issued by the forest department. That
Broadbase Lordship, it's an authority under the government of India. Lordship. Here the matter was placed, but on last line, Lordship, in the light of above, it is clarified that the proposal is not covered under, it is not required.
Proposal is not covered under the
Covered
category
under
of EIA.
category of EIA notification 2006. If it is covered under that notification, Lordship, then the matter requires to be placed before this authority. It is not. That's it. I am told, Lordship, that concerned executive engineer informed me about that the depot bill, actual depot bill is more than 1 kilometer away from the present hard filling site. That is what.
But there is a wetland which is being filled up.
Not wetland, Lordship. They have filled up the area just in apprehension that during the summertime, Lordship, it will be water logging will be there. That is why they have filled up that area, Lordship. And once the construction is over, construction is.
Then why you have not filed affidavit?
Lordship, in fact, this is the instruction I have received from the PW department. PW is not a party here. And this question arose today only.
District Commissioner should file affidavit.
Not.
Seeking instructions from all the departments whichever.
Well, the demarcation in respect of the Ajara circle, it is not complete, my lord. Lordship will give 3 weeks time, my lord. Let them, in the meantime, let them.
Yes, Mr.
My lord, my humble prayer is this, my lord, till the demarcation is made, there should not be any earth filling work, my lord.
They are claiming that earth filling is not in the depot bill area.
My lord, they have not filed any affidavit with that regard.
Petitioner.
One affidavit, Lordship, setting that earth filling is going on inside the depot area.
Let them give the exact location, my lord. Let them give the exact location so that we can also verify.
Has made a specific assessment that earth filling is going on in the depot mill area, which may result in which may severely affect the depot bill. Stop. Learned counsel appearing for the Mr. P. Nayak, standing counsel, appearing for the Guwahati Municipal Corporation, has submitted that as per his instructions, no earth filling is going on in the depot bill area. Stop. We direct Mr. P. Nayak to file an affidavit clarifying that no earth filling is going on in the depot bill area. File an affidavit of the concerned official by the next date of hearing. Full stop. Mr. D. Nath is also directed to file an additional affidavit regarding the demarcation of the depot bill area by the revenue department. This Tom.
He has wait for 3 weeks time so that he can complete the work. The Azara revenue circle, the demarcation is not yet done, not complete yet. And the persons are in the.
Just in the month of last week of July before the green bench. Before the green bench.
And has made a specific bottom line. Assessment or treatment or evaluation. Treatment. Assessment. Statement good.
Item 15, pass over, Mitra.
I have called Mr. DP Bora, my lord. I have called him, Mr. DP Bora. He said he was present before lunch, my lord. He was present before lunch, my lord. Now I called him again. He said he left for home, my lord.
What to do?
So, my lord,
Whether he is appearing on behalf of all the respondents.
Yes, all the contemnants. Yes. Because tribunal is giving us options saying that either you comply the order or get an order from High Court, my lord. Last paragraph, my lord.
Last paragraph of what? It is not a returning notice, has nothing to do with the contempt petition because this is duty as a contempt petition, therefore. One more chance is granted contempts to other comply with the tribunal order or to get the order from the High Court.
In spite of saying that matter is subjudice, my lord, and interim will be considered after service of matter. My lord, may justice service.
List after, list on, day after tomorrow, we list on so and so while showing the name of Mr. DP Bora
Yes, my lord, DP Bora.
as counsel for the respondent.
My lord, next date is fixed on 31st of this month, my lord.
Coming on 29.
29.
Daily list for admission item 45.
May I please, Lordship? For this petition, Lordship, I pray for 4 weeks' time for the filing of the counter reply. Lordship.
4 weeks.
Thank you, Lord.
Oh,
Supplementary list item 53.
Caveat is there, my lord. Caveat is there. Caveat is there.
Caveat is there.
And in the meantime, my lord,
Caveat may be discharged.
he is already taken over charge.
That is not correct.
Yes, I brought the order.
I'll just place the facts first.
We are aware of the fact.
My lord,
What's
sir.
wrong with the judgment
Yes,
of the
I'll come to that, my lord. My lord, this is against the judgment and order whereby the learned single judge had set aside my order as the in charge principal by adjudging the inter se seniority between the appellant private respondent and the respondent number 1 writ petitioner. Well, few admitted facts, my lord, which are admitted, my lord, is that, my lord, the writ petitioner was initially appointed in the year 1994 in ad hoc basis. That's an admitted fact, my learned senior friend won't deny.
But in the pay scale of this.
Yes, I agree to that.
Graduate pay scale.
Yes, I agree to that. My lord. I admit that in the graduate pay scale. But nonetheless, my lord, he was initially appointed in the year 1994. At that point of time, he did not have the formal graduation, my lord. He had a bisharat, which is not considered as a graduation degree, my lord.
Later on, the clarification is there by the
Yes, I'll directly come to the law points then, my lord, what I'm trying to urge, my lord. My lord, in my humble opinion, my lord, the judgment of the learned single judge is perverse on 2 grounds, my lord. My lord, there are 2 established service jurisprudence principles, my lord. The first one, my lord, admittedly, he was appointed in the year 1994. Then that post was abolished, and thereafter he was appointed in my school in the year 1998. I'm a substantive appointee, my lord, 96. Thereafter, in the year 2007, his ad hoc period was regularized retrospectively. So my first ground, my lord, the first ground is, my lord, retrospective regularization can be reckoned for all other purpose, but not for the purpose of seniority. And that is laid down by number of judgments of the Honorable Supreme Court. The second ground, my lord, the learned single judge had relied on a clause, my lord, Rule 14, to be precise, of the 2018 rules.
Yes.
My lord, can I just read the rules for a moment, my lord? Okay. My lord, could just give me a moment, my lord. Yes, my lord. My lords, my lords, may kindly turn to page number 35, which is the same book, my lord. Rule 14.
35.
Page 35. Was provided with the
Yeah.
book.
Rule 14 is there, my lord, at the bottom, my lord. Has it, my lord?
The post of headmaster.
The recruitment, yes. My lord would come to the proviso, my lord. That is what was relied upon by the honorable single judge, my lord. Provided that the seniority of a graduate teacher shall be determined from the date of receiving graduate scale of pay by the respective assistant teacher. Now, my lord, this proviso consists of two parts, my lord. First, it says a graduate teacher, a person who's in the cadre of graduate teacher, his seniority would be reckoned from the date when he received the graduate pay of scale. Now, my lords would kindly come to the meaning of graduate teacher, my lords, page 21 in the same book, my lords.
Yes.
Page 21, I. Graduate teacher. My lords, has it, my lord? Page 21.
Yes.
Yes, I'll read it, my lord. Graduate teacher means and includes the category of assistant teacher, classical teacher of higher secondary or senior secondary or high school or a high school, including amalgamated higher secondary school and senior secondary high school, for whose appointment and the minimum qualification is, my lord, would kindly take note, is graduate in arts, science, commerce from recognized university, including demonstrators of provincialized higher secondary school and senior secondary school. Now, my lords, to be in the cadre of graduate teacher, he has to have the qualification of graduation, which was admittedly acquired by him in the year 1997. Now, my lords, if he was not even born in the cadre, I am a substantive graduate teacher appointed in the year 96. Now, even assuming regularization, if I give up that point also.
At the time of his initial casual appointment,
yes,
he was not graduate.
No, my lords, graduation admittedly, my lord, that is there in their pleadings. He had acquired graduate qualification in the year 1997. So, my lords, unequals cannot be compared equally, my lords. They're settled law, my lords. A person who is not born in the cadre, he cannot, my lords, claim seniority, my lords, before the time he was born in the cadre, my lords.
So do you have any objection regarding the
No, I don't have any objection regarding the other part, my lord. No.
Direction given by the.
No, I cannot object to that.
Complete the process of regular.
No objection, my lord. But the thing is, my lord, since in my humble submission, my lord, that should have been the judgment, my lord. But since my lord has adjudged on the seniority, my lord, that would put me in difficulty, my lord, even later.
My lord will come to my lord. Page 54 of that book.
Yes.
Minimum education qualification, professional qualification for direct recruitment to the in the post of. It is not direct recruitment anyway. Graduate teacher. Graduate postgraduate from beginning university with at least 50% marks in their graduation appreciation or its equivalent. That includes the Hindi also. Government of Assam, sometime in 2005 has clarified it, that they are also entitled to be permitted to postal principal.
When you acquired this graduate qualification?
97, but what matters here is scale of pay. That was the graduate scale pay.
Whatever it may be, scale of pay, you may get the scale of pay of the collector. See, if you don't have any qualification, so prior to 97, there is no question of consideration of your seniority.
But
seniority at all.
But my lord, that notification, both the notification by the BTC as well as the instructor has not been challenged by them anywhere. That remains till date. If they really agree.
You just show us when you acquired the qualification of this graduation.
Graduation, post-graduation, I acquired in 97.
So then how your seniority relate back to the year 1996 before acquiring this graduation qualification, sir?
Now, first your lordship will kindly come.
He was appointed, you were appointed in?
96, my lords, in substantive capacity as a graduate teacher, my lords. And he was appointed ad hoc in the year 94.
Yes.
I was also appointed, my lord, in substantive post, sanction post. You also kindly come to page 44.
Forget, sir, substantive post, forget. Even though a casual appointment may be, your prima facie be of the view that this your casual term is also liable to be considered for seniority.
Yes.
But when you acquired the qualification, that's all. So prior to 1997, it can't be even taken.
No, your lordship will kindly consider. I am a senior Hindi teacher.
Whatever.
I am not a general teacher. So for senior Hindi teacher, what is required that I am qualified? That is equivalent to graduation.
Equivalent to graduation,
Yes.
yes.
So my lord, in that view of the matter, that's why I was appointed initially in the graduate school pay, starting from 3,500.
Without having graduation qualification?
No, no need. For Hindi teacher, classical teacher, they should be in the subject concern only.
That is not correct.
Yes,
I'll come to
yes,
that,
yes.
Lalit, my learned.
Yes.
That is not correct.
That can't.
Not correct, Lalit.
Yes.
Which one would be?
Minimum educational qualification and professional qualification for direct recruitment to the post of schedule third, which you have referred to.
Yes.
Graduate teacher, graduate, postgraduate from recognized university. That's all.
Yes. And or equivalent.
Or
equivalent.
So equivalent, which equivalent qualification you were having?
Yes.
Which equivalent qualification you were?
Visharad, my lord?
Visharad, you obtained in 1997.
No.
Then
1993, 94.
1993, no. Look here. And if that was equivalent qualification, where was the need for you for obtaining this qualification again?
My lord, he may obtain, he obtained B.Ed.
Twice BA. Twice BA.
My lord?
If you are already having a qualification of BA, where was the occasion for you to again have this qualification?
Thereafter, I continued the study. There is no bar, my
Continuously, you may postgraduate.
My lord, if I acquire PhD, can there be a ground for that? I was not qualified to be appointed at that time. Because I am not a general teacher. I was in. And my lord, in the meantime, I have taken charge by virtue of the order of the school. I have taken over charge.
I have not handed over charge, madam. How can you? There's no order. Lordship may kindly state the judgment, madam.
Then the counsel for the appellant has submitted that. Admittedly, the respondent has acquired the graduate qualification in the year 1997. However, ignoring the same, the learned single judge has observed that the seniority of the petitioner of the respondent is liable to be counted from the year 1996. 94, when he was appointed temporarily in the pay scale, in the graduate pay scale. Full stop. Learned counsel has submitted that it is settled position of law that a person appointed on temporary basis, that is seniority of a person for the period when he was appointed on temporary basis cannot be counted for the purpose of the tenure of a person. Tenure of a person. Tenure of a person. When he was appointed cannot be taken into consideration for the purpose of granting seniority. Full stop. Issue notice of stay application also. Stay application is there.
No, madam, I prayed for stay in the appeal.
Issue notice in the meantime. The direction given by the learned single judge to the effect that the respondent authorities are directed to hand over the charge of the post of principal in question on in charge basis to the private respondent shall remain stayed. The appellant the respondents are directed to allow the appellant to discharge the duties of principal in charge.
Well, I've already taken up charge. They have handed over charge.
Again, the principal in charge of the school concern, of the school in question. However, the respondents are further directed to fill the post of principal on regular basis as directed by the learned single judge in the impugned order within the stipulated time.
Very grateful, man. Deeply obliged. Deeply obliged.
Yes, sir. Concept of the respondent as supported the judgment passed by the- Learned counsel for the respondent as opposed. They are supported the judgment passed by the learned single. Supported the judgment passed.
अच्छा ये नोटिस को लेकर ना लेसा तो दी दो इशू नोटिस इधर रखते हैं
Item 46.
My lord, on instruction, my lord, we'll like to withdraw this petition. However, my lord, I humbly pray for liberty because members of this petition may have some individual rights. So liberty may be granted to avail all legal remedies.
Learned counsel for the petitioner and inspection has submitted that the petitioner association wants to withdraw this petition, however, liberty be granted to the affected individuals to file fresh writ petition challenging the provisions of the Assam Town and Country Planning Service rules.
Yes, there are three rules, my lord, because there are three
Service rules
of 2016.
to 2016, if occasion so arises.
Deeply obliged.
There is not a the prayer is not opposed, prayer of the counsel for the appellant is not opposed by the counsel for the respondents.
Deeply obliged.
Dismissed with liberty as prayed for. As withdrawn with liberty.
Item 47 to 49.
Liberty to challenge it in accordance with law, that will be
Liberty to
challenge in accordance with law, otherwise this, on the basis of this liberty, they will say.
Even though if they're without, not in accordance with law, we'll take care of that.
This liberty should not be taken as a ground for challenging the rules again. There will have to challenge the rules in
If
accordance with
occasion so arises or if any party agrees, they can very well challenge this.
violence.
Lordship, as regards item 47, my lord, this may be detached from the other items because this is this item, my lord, this subject matter pertains to Northern Assam, and therein, my lord, we have admitted there is an encroachment. Some steps have been also taken, my lord. This is from no, this is not Amsang, my lord. This is from the Northern Assam, my lord, Lakhimpur and the Tezpur side, my lord.
It's towards the northern side of the river Brahmaputra.
It may be kindly detached, my lord.
47.
47.
And what about 48 and all?
My friend is there, my lord.
In 48, your lordship, there was a survey conducted by the Survey of India regarding the boundary of the Amsang Wildlife Sanctuary. And the boundaries of both, the boundary in the records of the state government and in the survey conducted, they were found there was some difference. So rationalization process has taken place, your lordship, because lots of public utilities also came within the boundary of the sanctuary. For example, the army cantonment. So that process is now underway, your lordship. So I have the instructions. As per the transaction of business rules, they have to be placed before the cabinet, your lordship, and then have to be approved by the State Board of Wildlife and then finally by the National Board of Wildlife. So that process is underway, your lordship.
Item number 47. Item number 47 be detached from the bunch of writ petitions. This PIL number 76 of the 2018 separate after 4 weeks. In the green bench. Before the green bench.
Deeply obliged.
Learned counsel for the Respondent has submitted that the process of rationalization of boundary of Amchang Wildlife Sanctuary has been completed by the Forest Department. However, as per the Assam rules for executive business 2023, the approval of the cabinet will be required for the final rationalization. It is submitted that due to operation of the model code of conduct, the matter could not be placed before the cabinet, state cabinet. Full stop. He prays some time for issuance of the final notification of the boundary of Amchang Wildlife Sanctuary after getting approval from the state cabinet. Stop. Time period for is granted. List after 6 weeks. List after 6 weeks.
Deeply open.
48 and 49, 48 and 49.
Item 51.
Right, please, Your Lordship. Your Lordship, in this case, Mr. N.M. Kormakar was engaged counsel, Your Lordship. He has expired, Your Lordship. I was his junior, Your Lordship.
Okay, fine.
So sometime may be granted to obtain instruction from the appellant, Your Lordship.
Who was engaged earlier?
Lordship.
Learned concept of the appellant has submitted that Mr. N.N. Karmakar, advocate, is no more. And therefore some time may be granted to the appellant to engage a new concept. Time period for is granted. List after 8 weeks.
2 weeks time may be granted.
8 weeks.
Development.
Item 52.
Your Lordship may kindly give some time over.
For what?
We need some further instruction from the respondent number 7.
My lord, this case, my lord, is coming up, my lord, open, my lord. I am coming from Delhi. Whenever I come, they seek an adjournment. Now, my lord, it was on several occasions, it was stated before the bar by the former, my lord, Chief Justice of this honorable court. But my lord, it was stated on several occasions before this, my lord, bar by the, my lord, former Chief Justice, Honorable Mr. Justice Contempt Mehta, that this particular petition filed by the respondent number 7 here in my lord is not maintainable as no fundamental rights of the petitioner has been violated or infringed, your lord. And since then, my lord, they are taking time, my lord. Now, in this case, my lord, this facts of this case, my lord, is also covered by a very recent judgment passed by. Here in this case, my lord, it was stated that the B.Ed certificate of the present appellant, my lord, respondent number so is invalid. And consequently, my lord, his pension is being withheld by the authorities, your lord. Now, your lordship will find, my lord, that particular, my lord, in order at page 41, appeal is against 27, 2020. And my learned friend, my lord, the learned counsel for the NCT Natural Council for Teacher Education is there, my lord.
Just your B.Ed qualification was declared as unrecognized because the NCT has granted recognition on a later date.
My lord, I'm sorry, your lord.
Your B.Ed qualification is declared as unrecognized on what ground?
My lord, reason is, my lord, learned single judge, your lordship has given at page 148.
Yeah, read.
Your lordship will find the authorities, my lord, page paragraph 22, my lord.
Yeah.
The authorities of said Vivekananda College of Education, Karimganj, and the respondent number 7, that is me, my lord.
Sir, this para 22
Para
is said,
22, my lord.
but from the B.Ed degree pass certificate issued to the respondent. by the Assam University on 8/3 election, the writ petition goes to show that respondent 7 Vivekanand College of Education was admitted to the degree of bachelor education.
1996, I was not admitted in 1996.
1996 and the respondent Assam University Vivekanand
Authorities of State Vivekananda College of Karimganj and the respondent number 7 failed to place anything before the court as to when and by which communication State Vivekananda College of Education Karimganj applied for his recognition from the NCT and as to when and by which order stroke communication the NCT granted recognition to State College of Education. Prior to the communication, NCT dated 13/3/2001 year law. Now, they say that the institution from which I had passed, it was recognized on 13/3/2021, my lord, and I failed to show any application or correspondence or, my lord, other things, my lord, prior to the date. And in that way, my lord, the learned single judge, my lord, ignores the documents your lordship will find at page 31, page 33, page 37, page 38 and 39 of this appeal, your lord. Now, further, your lordship will find, my lord, paragraph 24, my lord, second line. The NCT Eastern Regional Committee granted its recognition to Vivekananda College of Education, Karimganj, Assam by an order dated 13/3/2001 for starting B.Ed course for 1 year duration from academic session 2001-2020, 2002, your lordship. So the, my lord, findings of the learned court below, your lordship, that prior to 13/3/2001, my lord, this institution was not recognized. Now, my lord, I will take your lordship to, my lord, firstly, my lord, to page, my lord, firstly to page, my lord, 29. The college was there and I got admission on 22/6/1995, your lordship. So, my lord, this college was there, my lord, prior to the coming of this particular act, my lord, on 1/7/1995. Now, act came, your lordship will find, my lord, page 30, my lord, on from 1st of July 1995. And then, my lord, your lordship will find there is a, my lord, permission granted by the Assam University, my lord, 25/7, whereby this particular institution was.
When this institution has applied for recognition?
And then, my lord.
When it's like for recognition.
I have. Now, my lord, your lordship may kindly turn to page 33, your lord.
Yes.
33, my lord, I applied, the authorities applied, Vivekananda.
When?
Vivekananda Institution, my lord, of education applied, and their application was, my lord, when I do not know, but they are saying, NCT, my lord.
Yes.
NCT is saying, my lord, thanking you for your letter dated 15/8/1996. And this particular letter, your lordship will find 12/9/1996. Please find and prove.
You applied in the year 1997, 1996.
1996, your lordship.
And recognition was granted in the year 2001.
No, it was granted firstly, my lord, provisional.
Whatever it may be.
Provisional 1998 and ultimately.
1998, it was provisional recognition was granted.
Yes. Yeah,
And
my lord,
then 2001, they permanent recognition.
prior to that, my lord, I was allowed to continue with the, my lord, classes.
Mr. Consul, we have already decided, Mr. Consul, we have already decided that once recognition is granted, then it would deem that it relates back to back date. It relates back to date when they have applied for it. The division bench has already.
My senior is on regular court 1, so I am just appearing on behalf of.
Your senior is in another court.
Yes, sir.
Call him. Go and call him. Call him, call him.
Your lordship, facts are covered, my learned friend will agree, your lordship, NCT.
Covered by Musobirali's case, my lord.
Musobirali's
State of
case,
Assam.
covered, your lord. Paragraph 9.
Your lordship already decided that issue.
So our application was pending. We are allowed, my lord, the college was allowed to continuing. My lord, university granted affiliation or permission to conduct us, my lord, the classes 1995. And my lord, ultimately 1998, your lordship will see, my lord, the provisional, my lord, recognition was granted. Then again, my lord, in this year, my lord, lastly, my lord, 13/3/2021. So the contention that, my lord, it was granted, my lord, recognition for the first time on 13/3/2021 is not correct, your lord. Your lordship, my lord, may kindly see, my lord, page 31. Grant of affiliation or permission by the university, your lordship. Page 31. And again, my lord, page 31, original, my lord. And then there is a letter, page 33, from the, my lord, National Council for Education, that we have received your application dated 15/8/1996. Now, they had enclosed a circular, my lord, to us. And you said you are requested to apply for recognition in proper form, which can be obtained from this office. It is this office, your lordship, as per the next page, original one, your lordship. And accordingly, my lord, the certificate, my lord, I was admitted, my lord, in the year 1995 for the session 1995-96. And my lord, I passed this and my certificate, my lord, 8th of March 1997. Then, my lord, the Assam University again, my lord, affiliation committee and all that. Now, my lord, 26/3/1998, my lord, page 37. My lord, they had asked the college to proceed with an intake of approved university state government vote as the listing, my lord. And ultimately, my lord, your lordship will find 38. 1 year provisional recognition. That means, my lord, recognition was granted prior to 13/3/2021. But the contention that, my lord, this particular college, my lord, was not recognized prior to, my lord, 13/6/2021 is not correct, your lord. And for that purpose, your lordship may kindly see, my lord, this national, my lord, NCT Act, your lordship, National Council for Teacher Education Act, my lord, was amended. And, my lord, we have included that, my lord, page 41. And, my lord, page 42, my lord, section 18B, subsection 4.
Yes, Mr.
My lord, in this case, my lord, I will pray for your for accommodation for 2 weeks, my lord, because
He's complaining that every time,
No,
on every
no.
occasion, he is coming from Delhi and every occasion you are seeking adjournment. This can't.
Let my senior friend, my lord, complete his argument, my lord. And because, my lord, I have searched some judgments, my lord, and I have found, my lord,
What judgment?
judgments I'm submitting, my lord. What
You
happened,
have
my lord?
found such judgment,
This
then give
honorable,
us the judgments.
this honorable court has given judgments in 3 writ appeals, my lord. In 1 writ appeal, it was allowed, 2 writ appeals dismissed, my lord. And then I have searched, my lord, that in the as per section 16 of the NCT Act, my lord, if from the date of coming into force, the appointed date, my lord, those institutions which are not in existence, those institutions are not entitled, my lord, to issue any certificate to run any program, my lord.
This institution was in existence.
No, my lord.
Yes.
As per NCT affidavit, they have also admitted, my lord.
What about the affidavit? The institution was very much in existence.
No, I will, my lord, place, my lord, on record, my lord, after. Therefore, I need some time, my lord. The affidavit, 2 affidavits have been filed by the NCT, 1 in the writ petition and 1 in the, my lord.
Case is covered by the Musabbar Ali judgment.
No, my lord, that issue is not decided in this, in that writ appeal, my lord.
What issue was decided?
Issued, my lord, whether on the day of coming into force of the NCT Act, my lord, whether the college concerned in question had the authority, had the affiliation from the university. That is not, that is absent.
There is no question actually.
Because, my lord, the Honorable Supreme Court, my lord, Honorable Supreme Court in many other cases also given, when there is a special act, my lord, which prescribes that the council should provide the recognition, the university thereafter only after obtaining the recognition, my lord, would give the recognition affiliation to the concerned institution, not prior to that, my lord. That is, my lord,
Here,
here.
Here the question of affiliation is not there.
No, my lord, I'm submitting. Here, my lord.
Here the question of affiliation is not
Yes,
there.
yes,
The
there.
direct single judge has simply non-suited this
My lord,
respondent or appellant on the ground that the recognition was granted in the year 2001, whereas he has obtained that degree or acquired that degree in the year 1997. This was the only point.
my lord,
And we have already taken a view that once the recognition is granted, it will relate back to the date when the application is filed.
no, my lord.
No, my lord. So what do you mean by no, my lord? We have already decided.
Decided, my lord, that
my lord.
therefore my humble submission, it will be placed before the larger bench, my lord. Because, my lord.
Placed before the larger bench.
Yes, lordship. Because the issue, my lord, which is there is not decided in another, I've searched in many other high courts, my lord, that the issue has been decided.
Decide. If not decided, we'll decide again.
Then I will, therefore I'm praying, my lord, I will give the I will make the compilation, my lord, of the judgments and I will produce it, my lord, 2 weeks time. Will be great. I will make. That is not decided. That is not decided, my lord. In any of the judgments I have seen, my lord, Honorable Supreme Court. And also I have read. Also I have read, my lord. Also I have read the judgments, 3 judgments of this honorable court, and also.
When?
After 2 weeks, my lord. Any date, your lord.
Not at all 2 weeks.
Then 1 week, my lord, your lord.
No, 1 week in this week only.
I will have to.
You will have to, whatever you will have to have it. When?
My lord, I am on 31st, my lord, my last day in Guwahati. I will have to go on. 2nd I am going, your lord, going back.
You are staying in Guwahati only?
Earlier I was in Guwahati, my lord. For 40 years I was there in Guwahati. Then I had to go, my lord. And my lord, I am now residing at Vrindavan, your lord.
You are residing in?
Vrindavan, your lord.
Vrindavan?
Vrindavan. Your lord, and concern side.
It's too hot. वो गर्मी बहुत है वहाँ पे. आप थोड़े दिन यहाँ रहो ना. Thursday.
Just one. I think with regard to item 44, my lord, regarding that Oxoco special PP. I'm not sure, but I'm told that there is some amendment of section 24 CRPC, Assam amendment. If that has any bearing with the case, my lord, I'll place it tomorrow morning at 10:30. Because
section 24 is
24. Because now possibly pursuant to that amendment, the post of PP has been made a regular cadre. And there has been an advertisement also. Whether that has any bearing in the
regular cadre means
regular employee of the
so
government.
cadre post, then what is the procedure for recruitment?
Director of prosecution is there, my lord. So I'll just place. I just find out. I'm not. Huh? It will be effective from 1st of July. So I'll place the message
1st of July.
My lord. No, whether it has any bearing or not. I'll place it tomorrow at 10:30.
Okay.
If there is any, if it is relevant, my
It is, anyway, we have reserved the order.
Yes. I'm just placing it because otherwise it's.